యూట్యూబ్ ఓపెన్ చేసినావా స్టూడియో? హలో.
Hello.
ఓకే.
Check. వాళ్ళ దగ్గర ఉంది కెమెరా ఒకటి. హలో హలో హలో.
హలో పశుభాయ్.
సార్
ఓకే. అది యూట్యూబ్ లైవ్కి వెళ్ళిపో.
చేసా వస్తుంది యూట్యూబ్లో.
ఓకే.
Hello, Sudhir sir, can you hear us?
Loud and clear.
All right, thank you. So change for details. First one.
This seems okay, right? I think you can just test. Yeah, it's okay.
Is it all right? Working?
You just leave it up to use from there.
All right. Good afternoon, everyone. A warm welcome to the post-lunch session. I don't see the person who basically asked the panel's responsibility is to keep all of you awake. I thought actually he represented himself as me, the people. So therefore, it is basically keeping him awake. So hopefully Siddharth will come soon. But welcome to this panel on federalism. We have three panelists in person. Sudhir unfortunately could not make it in person, but he is there online as you can see him. And we are going to have, in Siddharth Raja's hope, a very fiery conversation. So I'm not sure whether federalism can generate such a energizing thing, but he's hoping the panelists are such that there is a possibility of a lot of energizing conversation happening. There is much happening, of course, on federalism. I'm sure 370 case is the one that is on the top of everyone's mind, but there are so many issues ranging from the role and function of the governor is another sort of major thing. Financial federalism is another thing. So there are various aspects. I'm not speculating what the authors, the panelists are going to say, but I guess they will certainly touch upon a number of issues that have convergence with some of these major developments that happened in the last 1 year. And so I would just go by the order in which the panel is listed. So I think we are going to begin, therefore, with Alok. Alok works with Vidhi Center for Legal Policy, and he heads the office in Bangalore. And so I suppose he's going to bring in his own experience of both conducting research as well as the cases that he's following in this particular regard, right? Alok, so.
Okay. Thank you, Sitaraman. And good afternoon, everyone. In a previous Courts and Constitutions conference, we had Professor Blackshield, Tony Blackshield from Australia, and he brought the house down with a song. And sorry for raising your expectations, but I am not going to sing. But I will try my best, which is to tell you the story of how the Supreme Court, which decided that federalism and democracy are such important, fundamental, basic features of our constitution when it came to Delhi, decided to abandon these in the context of Article 370, in the context of Jammu and Kashmir. Okay, so I won't try to go in depth into the facts of each case because I know I have limited time, 10 minutes. Yeah. So, and I will go into the, what I think are the most important points, which are necessary for us to understand how could the same Supreme Court, the two Delhi cases came in 2018 and 2023, and the 370 judgment which came out in later the last year, how could the Supreme Court take such divergent views? Okay, so let me just remove all the trivial objections. The trivial objections are, well, it just had to do with different facts of the case. That's trivially true, but doesn't explain enough about this. The other trivially true thing might be removing Delhi's or fighting with Delhi was not a core political agenda of the BJP, and removing Article 370 was a core agenda of the BJP, and therefore the Supreme Court decided that way. That I don't think fully explains it. Nor does it, I think, fully explain that, well, the combinations of benches were different. So what if there was just one or two common judges, which happened to be Justice Chandrachud in these two cases? So I want us to just get out of all of these kind of trivial ways of understanding judgments and get into something deeper. And what is that something deeper is to understand two very important things about India's federalism. Number one, and I'm sure you're familiar with this concept, but it's at the risk of a little bit of repetition, which is the asymmetric federalism. Asymmetric federalism is not every state has exactly the same relationship with the union, right? Now, that's a very basic description, but what I want to go a little bit further in depth into in this discussion is why it's so important to preserving India's federalism that we have an asymmetric federal structure. All right, that's number one. The second thing is we assume that there is union territory and there is state, right? But it's not always that clear. In fact, Jammu and Kashmir, I think, was more than just a state. And even among union territories, you have pure union territories, perhaps like Lakshadweep or Andaman and Nicobar Islands. Then you have union territories with a legislature such as Pondicherry, and you have a union territory with legislature and powers to make law from the constitution itself, which is the NCT of Delhi. So you're actually seeing a spectrum. It's not just this way or that way. Perhaps at the two ends of the spectrum are pure union territories, you might call, and more than a state, right? So this is not like a fully well thought out idea, but this is just an idea for you to keep track of. I haven't thought of two names for these ends, but Delhi falls somewhere in between, right? Delhi is not a full union territory, nor is it a full state that way. It falls in somewhere in the middle in the spectrum. So keeping these two things in mind, let's try and understand what the Supreme Court has done in the context of the two Delhi cases and the Article 370 case. In the two Delhi cases, what the union government was trying to do was assert the power of the lieutenant governor, who's appointed directly by the union government on matters which the Delhi government believed it had lawmaking power. These are a range of issues. I won't go into any specific one, but the matter hinged on the interpretation of Article 239AA, right? And what the Supreme Court essentially says here, or rather one step back, what the Delhi High Court had said in this particular case is that actually the LG is the ruler of Delhi, and the CM is just, then the CM and his cabinet are in pure advisory functions, essentially turning it into the Nizamate of Delhi. This was the Little Delhi High Court judgment, which was in challenge before the Supreme Court. Supreme Court obviously sets it aside. Supreme Court says that the Delhi legislature has plenary powers. And if the Delhi legislature has plenary powers, it means that the Delhi executive also has plenary powers. Not as much as any other state, but much, much more than any other union territory. All right. And I'm simplifying this because I want to get to the main point, because how the court arrives at this conclusion is not just an interpretation of Article 239AA or reading 245, 246 and the lists. The Supreme Court uses two very fundamental concepts of our basic structure, which is federalism and democracy, and sees them as being fundamentally interrelated, fundamentally feeding off each other. The Supreme Court kind of makes this argument that federalism allows people to choose the government that is closest to them and works most for them. And you cannot say that to hell with your local government, I'm going to tell you how to run your part of the country, right? Again, I'm simplifying in the interest of standards in the interest of time, and the fact that if I read out from the judgment, all of you will drop dead and fall asleep in a minute. So to simplify it a little bit, what the Supreme Court is essentially saying is that Delhi, we will elevate you to more than being just a union territory or even just a national capital territory. your status is constitutionally protected, but it's constitutionally protected not just because Article 239 AA says these nice things, but because our democracy and our federalism mean that when you are choosing your representatives, right, they have to be given real powers to act as your representatives in an executive government of some sort. So you have Delhi, whose status as a national capital territory, somewhere between a state and a union territory, is somewhat constitutionally protected. Now we come to Jammu and Kashmir, right? Now we know Article 370 was upheld. Sorry, or rather, the removal of Article 370 was upheld. Now, I don't know the exact legal term for what the government did, because every time I talk about it, I use a different term. So I'll use removal here. If you can suggest a better term, I will use that. What effectively happened was that under Article 370, Clause 3, you have the power of the president to abrogate Article 370 by issuing a presidential order. But this presidential order can only be issued with the concurrence of the Constituent Assembly of Jammu and Kashmir. But there is no Constituent Assembly of Jammu and Kashmir. There hasn't been a Constituent Assembly of Jammu and Kashmir since 1957. So the question comes up as to how did the president in August 2019 invoke their power to abrogate Article 370. It is effectively using 370 to destroy itself. The way the union government tried to find a solution around this was to amend the constitution using Article 300, forgetting the exact thing, which defines Constituent Assembly, and to define Constituent Assembly of Jammu and Kashmir to mean the Legislative Assembly of Jammu and Kashmir. And because there was no Legislative Assembly of Jammu and Kashmir, Parliament could exercise that power and give concurrence for the abrogation. Supreme Court rightly says this is ridiculous. You cannot do this. You cannot use such a circumvention of Article 370 to redefine Constituent Assembly of J&K to mean Parliament of India. But nonetheless, what the Supreme Court says is okay to do is to act as if the words that the proviso to Article 370 Clause 3 do not exist at all, which is that the proviso which says that you cannot issue a presidential order to abrogate Article 370 without having you can therefore issue this order without having the concurrence of a Constituent Assembly of J&K. Now, how does the Supreme Court do this? The Supreme Court does this, in my view, by a very dishonest reading of history. And that dishonest reading of history is something which I haven't found too many other judgments which do this. The Supreme Court goes into great detail into arriving at how Kashmir joined the Indian Union up to 1950. But after that, the Supreme Court does not want to look at events after that. The Supreme Court sort of wants to stop there, because if you stop your clock at that point of time, you can make the argument that, yeah, actually Article 370 was temporary, transitional, maybe not intended to be the final settlement of affairs between the government of India, between the Union of India and Jammu and Kashmir. What it doesn't do and what it cannot do, or rather where its argument would have fallen apart, is if it had extended its history up to 1957, it would have found out that the Constituent Assembly of Jammu and Kashmir had dissolved itself, right? Which effectively meant that the relationship between the Union of India and Jammu and Kashmir was no longer governed by a temporary Article 370, it became a permanent Article 370. Now, this is not a very original argument on my point. There have been other people who have made it, including A.G. Noorani and a bunch of others. But I'm sort of simplifying why I think the court's approach to interpreting Article 370 was dishonest. It was dishonest because when you say, I'm going to make a historical argument, right? Because you are sort of not just looking at the side note of that article. Even the side note doesn't completely explain the scope of a provision. You will need to find other circumstances to justify it, and they find these other circumstances on the basis that, yes, this was intended to be temporary. Look, because up to 1950, this is what happened, and they stopped the clock at that point of time. But why do they do all of this? And what does it tell us about the Supreme Court? Why do they do all of this? Is because there is no other way for them to justify why we have performed a magic trick which has made the proviso to Article 370, Clause 3 disappear. Because that's what that has been done. You need to do all of these exercises to do it. And at the same time, when the petitioners have raised the points of federalism and democracy, the court does another, not a magic trick, but I guess another effort, another illusion to say, actually, these are not issues at all. These are not questions at all for us to be decided. We don't even want to go into it. I think Justice Bhatt in his opening remarks kind of hinted at this, and I want to make it explicit. The court performs a complete abdication of the judicial function by simply not going into the most fundamental important issues in the Article 370 case, which is, how is this acceptable? How is this to stop there. I want to add one final thought for you to consider. What informs both these judgments is a stream of thinking that we should be able to critique the next time a case comes up. And what is that stream of thinking that we need to critique is that the court isn't being dishonest in the context of Delhi. It does feel that, yes, federalism, democracy are important things, but they are important for states which have already been integrated into the Indian Union. It doesn't think Delhi's accession or Delhi's creation or somehow it needs to make a historical argument for its justification. They do go into history. But the court seems to be saying, right, and this is my main argument, which I sort of end with, the court seems to be saying that there is a core of India for whom all these nice, wonderful principles of federalism, democracy can be applied with, upheld, and actions of the union can be pushed back against. But there is a periphery to India whose relationship to India is still somewhat uncertain, and they need to be integrated in some way. They need to be dragged somewhat kicking and screaming into the mainstream. And only when they're fully integrated, we'll think about things of federalism, democracy, and all of that. And this is a problematic reading because asymmetric federalism isn't just an intermediate step to some full integration of the country. Asymmetric federalism is the way that the Indian Union relates to all states, not just this idea. And this is an idea I have no doubt about it. But, and this is the dangerous thought for us to take away from this. If the union government writes something like that in the context of Nagaland, or in the context of Mizoram, or in the context of states that are seen as being in the periphery who have not been fully integrated into the Indian Union, it might arrive at the same kind of conclusion that it did in the context of Jammu and Kashmir. So with that provocative thought, I want to sort of leave this and we can perhaps discuss in detail. Thank you.
Yeah, thank you, Alok. I'm sure the lunch is already off and people are completely awake. It's clear with that jolt. The next panelist, I'm not going to even make an effort to comment on what happened. I may say a few words at the end. Shadan Farasat would be the next speaker. Shadan is an advocate in Supreme Court of India and a former alumnus of NLSIU. He's actively involved in many cases, so he's going to bring in his personal experience in presenting a case on the way the federalism is being looked at by the courts. Thank you.
Thank you, Professor Sitaram. It's a real privilege to be part of a panel with two of my former teachers, Professor Sudhir and Professor Sitaram, both of whom taught me when I was in law school. Yeah. So quickly, I'll begin by... Okay, I'll speak into it, sure. So quickly, I'll begin by yesterday. So Avni here was put with the responsibility of chaperoning me from the airport last evening here. And she asked me a question. And she said, why is it that in Delhi, in state elections, they vote one party overwhelmingly, and in national elections, they vote another party overwhelmingly? And I said, that's federalism, Avni. So really speaking, federalism in that sense is we the people expressing two different meanings to that we the people in two different sets of elections. So in a national election, you will have one set of priorities and a party may be better focused for that. And in a state election, you will have a different set of priorities and you will have a different party maybe fit for that purpose. And as Ambedkar said, the demarcating feature of federalism is that the distribution of power between those two sets is done by nothing less than the constitution itself. So it can't be eaten up by like the bigger creature. So if it's a parliamentary statute, it's easier to eat up. Of course, if it's an executive notification, if it's a devolved government, it can be eaten up pretty quickly. But once the constitution divides those powers and those two we the peoples are expressed in the constitution, their spaces are demarcated, their powers are there, and their responsibilities are there. What we have seen, and I think I've been part of a lot of this litigation over the last 3-4 years, but even in the last year a lot, is that there's an enormous stress on federalism. Enormous stress in every context one could imagine and one could not have imagined. So of course, the obvious case is we have the 239 AA scenario where you have elected government not being able to function. You win one constitution bench judgment, that's not sufficient. On a point still contested, you win a second constitution bench judgment, that is sought to be overturned. So how does a government function? So that's one element of it. And the other element of it is what, and here the Supreme Court has broadly performed its duty as, you know, in both the cases, maybe in the second case a little belatedly, but they came on the right side, on the side of federalism in both the cases. And there's another example which we have seen through last 1 year and which has really come to head now in what has happened in the last few days, is federalism survives if there is a multiplicity of voices in the political space. I mean, there's no point to federalism if the central government in all cases will be run by the same party as the state government. So real meaning of federalism is that people should have real choices at state and center and vice versa. And of course, in a given case, they can choose that both the state and the center should be governed by the same entity. What we have seen is a targeting completely of the opposition space of the political parties themselves. And that means that the ability to compete and offer a choice to the people is gravely limited. Now, the Constitution itself envisages a structure. If you look at CBI, Central Bureau of Investigation, it is entry 8 in list 1. Its jurisdiction was extended to states. On its own term, it's only a police force for union territories, which are controlled by the central government. Its jurisdiction was extended to states under entry 80 through an interpretation of the Constitution by a judgment which said state there, UT there can be read as state, but subject to the concurrence of the state to whom the power is being extended. So the Constitution envisaged a situation where a investigative agency of a federal unit can be running havoc with the federation. And that's why the 7 months. Unfortunately, the hearing has not been going on because the state, for one reason or the other, takes time. But the real point is that there is an inherent risk in allowing an investigative agency or one unit to investigate persons responsible for another unit. Because it's inherently meant to destabilize the other side. Now imagine a situation where state police were to start investigating central government ministers for corruption. It happened in Delhi. I mean, it was tried. The Supreme Court said, no, sorry, you can't do it. Rightly so. There's an inherent problem there because they are your competition in the federal space. You can't do it. You will destabilize them. And what we are seeing now is the exact opposite of it. A little known agency, which was not even much known, much used, is running havoc through the country as we speak. And this is after we have had a model code of conduct which has been imposed, where, like somebody in the other panel said, this is the most politicized time. The election cycle is the most politicized time. And in that time, if a central agency can be arresting leaders of the opposition group, in that time, if they can be effectively cutting out funding of the opposition parties, what to talk about free and fair elections? Free and fair we use loosely, but they're different words. Free is okay, everybody's free to vote, there's no vote rigging, that's free. Fair is you need a level playing field. That's fair. It has an independent meaning from free. So I think it's the first time, at least in my living memory, we are seeing the potential of an allegation being made that, listen, the elections, the national elections which are coming up may be free in a certain sense, but may not be fair given what all is happening. And it's a very serious issue. We can't take it lightly in the context of federalism. So, and here I would not go on too long, but I just want to put it for consideration of all of you, is the Supreme Court has on this account been very, very behind the curve. It really has had multiple opportunities to correct this, and unfortunately, it has not taken any of those opportunities. So for instance, PMLA itself, it's a very draconian law in many ways. The maximum punishment is 10 years, but you can't be given bail without merits being examined. Now, what is so special about a provision which maximum punishment is only 10 years, not even life? IPC has so many life and death provisions, but there also there's no merits bail. So what is so extraordinary about this offense? That it's a merits bail, right? Now, all of that was examined in a judgment. Judgment came out very, very one-sided, sought to be reviewed. That has not been heard for a year and a half. Huge problem. That should have been by now decided. Second, last year, a bunch of 14 political parties from the opposition went to the Supreme Court in April, saying, listen, agencies are being misused with data, 99% being targeted opposition. How will federation survive? That was the question. We raised a pure constitutional question before the court. And the court's answer was, listen, you come in an individual case when it's being misused. But individual cases are not a solution to systemic problems. It can never be. And we are seeing that now. How many people will keep on going individually to get that neutrality resolved? It's impossible. So I think on these kind of things, we really need to consider, because the direction we are going in constitutionally in terms of having a genuine federal space is not looking positive. And I think, unfortunately, on this issue at least, the Supreme Court has been behind the curve. Maybe they have not seen it as to what it is. And I think I was telling them that I think students here are very, very aware, because somebody in the morning session said that what do you do with the executive which is constantly pushing back? Like how can the court be responding at the same pace? Because courts are slightly more evolved institutions. They hear both sides. They'll take their time. Judgments will take time. So how do you sort of contest that? I think the courts also need to realize what they are defending and what they need to protect, and they need to evolve in that process. Because if you are going to go by the conventional element of adjudicating, you are assuming that the executive is also functioning in a conventional manner. But if the executive is hyper aggressive and basically taking away all your rights and coming back and pushing again and again, then you need to have that ability to at least restrain them at some level and draw those lines. So I'll end with where I started. The lines of demarcation between the two wings are demarcated by the Constitution itself. It's for the Supreme Court and the High Courts to demarcate the line and police that line. In some cases, the Supreme Court has policed that line well. In other cases, it has not. And we are seeing some of the consequences. The other thing I want to flag is, one of the things we have seen is all the constitutional litigation, substantial contested constitutional litigation has moved to the Supreme Court. And that's not happened just like that. I mean, even when I was a student, most decisions first cut would be at the High Court level, appeal would go to the Supreme Court. That doesn't happen anymore. So everything goes to the Supreme Court. The reason for that is, I think at some level, the High Courts have just stopped deciding contentious constitutional matters. They just don't take a hit at those matters. They just get adjourned. So if litigants in the system know you're not going to hear, so you're going to go to a place where there's a chance of a hearing. And I think that's unfortunate, because really speaking, we should not have too much centralized constitutionalism only at the level of Supreme Court. The history of this country is that constitutional law has developed all over the country. And I think that is another problem which we must consider in the context of federalism, because actually state high courts are as important for federalism and for constitutional adjudication generally as the Supreme Court. So I'll just end my address with that. Thank you.
Thank you, Shadan. We heard two lawyers, very hard-hitting take on the way the federalism is under stress in the last 1 year, if not few years. Now we will hear Sudhir, who is Vice Chancellor of National Law School of India University in Bangalore. I'm assuming the tone and the approach would be a more scholastic and academic. So let's see what Sudhir is going to say.
Yeah, thanks, Ram. May I just confirm that you can hear me? Yes?
Yes, we can hear you. We can hear you.
Thank you, Ram, for also raising the bar. And I don't know if I'm going to meet this or disappoint. May I first say thanks to the Courts and Constitution team and Nalsar for the invitation. Professor Krishna Deva Rao for the initial invitation, and Siddharth for following up. And the student team for promptly getting me here. I'm sorry I'm not there in person. And I'm sure I don't see full halls like this too often on austere topics like federalism and stuff. So I'm clearly missing something. That all of you are showing up on a post-lunch session to talk about federalism. Shadan and Alok have set a very clear set of ideas around the federalism problem. I'm going to try and do something quite different. I'm not going to focus on a single case or two. I'm going to try and do a sketch. My understanding of the Courts and Constitution effort has been to try and look at the year past. And I'm going to try and do that. Try and see what 23 and 24 and the first quarter of 24 have been like, and try and build a map around some issues that might be worth paying attention to. On all of these matters, increasingly, I rely on the work of my colleagues at the Supreme Court Observer. Today is no different. We've been doing some of this work over the year, and I'm relying on many of those conversations and ideas and in what I say in the next 8 or 9 minutes. Let me start by trying to build this kind of map. There was a time when most of us, Sharan was kind enough to say that we taught some constitutional law, and when we taught federalism, this was mostly seen as Article 356 story. And of course, we did other things. We were very interested in local government and multi-level governance and so on. But we mainly focused on that kind of story. Most of the writing right up to the 2000s was about 356. And what is striking is that 356 has gone away in some important ways. And 356 is not what shapes federalism talk today. But a lot else has come in, and it's almost become surprisingly that federalism is almost the most important topic in the Supreme Court. And you couldn't say that for previous decades. And it might bear some inspection as to why that is the case. So we seem to have very different types of cases, and let me map what's been done already and then move on to some stuff that's not been done. This entire position with respect to union territories and states has gone through something of a tortured decade. One part of this puzzle seems to be, what do we do when union territories transition into states? On that, we have two cases. We have the Puducherry case, which is about Article 239, and the NCT cases, which are about Article 239AA. We thought that NCT was done and dusted, and we put large benches to work, and maybe the legal issues are all sorted, but it seems to keep coming back, and sort of there seem to be many sequels, and I don't know how many Roman numbers we will have to add to the NCT series. It seems that NCT 239AA seems to be a particularly complicated article, because unlike the other UT to states transitions, it has an aid and advice provision, but it also has a division of subject matter, right? Almost reminding one of a pre-colonial regime with a diarchy, right? I mean, if you were to conceptualize in constitutional terms, what is 239AA? it most resembles a diarchic model. And why was that diarchic model chosen? It's unclear, but clearly the important thing seems to be that it's capital territory. That diarchic model plus the odd aid and advice requirements has generated more heat and dust than light, and we don't seem to be able to get over what might be a constitutional principle that can mediate the political competition in the National Capital Territory. In Puducherry, the 239 A cases are much easier in the sense that there is straight off aid and advice provision. And the only question there is whether aid and advice is like every other state in the union, or is it special? Now, it's another matter that the court has struggled with this question and seems to dither even today. And I guess we will have to wait out the better part of this decade before we know whether these special models of UT governance will work out. On the evidence today, we're in deep waters. The Article 370 question to which Alok spoke about, I don't want to repeat some of the themes that he explored, seems to be going in the other direction, because that's not a UT to state conversion, but a state to UT conversion. Now, for those of us who have worked through the history of the Constitution founding, and we know the Part A, Part B, and all that, the Part A, Part B states, and so on, we kind of assume that the UT status was a sort of state in waiting status. That is, that you only went in one direction. You went from being a UT to a state. And what is difficult in the 370 matter is that we now discover that we can go in the opposite direction as well. States may become UTs. Now, apparently for the court, this is a trivial observation. Yeah, it happens much in the way that I'm putting it to you today. Or sometimes states become UTs, sometimes UTs become states. But it seems that there's a deeper constitutional tussle at the core of this. If we allow states to become UTs, then the identity of the federal regime may break down. And somehow, while some arguments in court make this point, it seems to have escaped the court altogether. And we are now in a constitutional position where it is constitutionally valid for the union to unilaterally convert states to union territories. This is new. This is new in Indian federalism, probably new in any federalism, because one of the things we assume for a federal compact to hold is that the identity of the units is sacrosanct. If the identity of the units is up for grabs, where one unit can determine the identity of the other, then all balls are in the air, anything can happen. And so the 370, so I look at the 370 cases and then the NCT and Puducherry cases as kind of their corollary cases. They're just different in the direction of movement. And the court would do well to try and build this kind of analogy because a principled position might evolve. Let me move then to the other cases. So this was one cluster of cases in the last year. The second cluster of cases that I want to work through, and I'll do this more quickly, is the Article 200 cases. Now, generally speaking, we understand that unlike with the union government, the union executive, the executive power of the union is vested in the president, but the executive power of the state is not vested in the governor. Right? There is no vesting clause as a constitutional matter. We have struggled, though, to then articulate what precisely the governor is meant to do. The Constitution clearly places the governor of the state in a diminished position vis-a-vis the president, but what's the role of the governor vis-a-vis the elected executive? And clearly, we are testing the boundaries of that role in the Article 200 cases. Now, the Article 200 cases all deal with the reservation of assent to, I mean, or the non-granting of assent to legislative bills, and in some cases, passing it on to the president. So squatting on bills or then passing it on to the president at a later date. We have the Tamil Nadu, we have the Kerala cases, and now I'm pretty sure there are many more to follow. You know, and Shadan was very kind to say that we were his teachers, but the one thing we didn't teach him was Article 200, because nobody taught Article 200. We thought that Article 200 was the kind of article that dealt with arcania, everyday affairs, you know, not the kind of thing of high constitutional principle. It was the parts of the Constitution that we were willing to sacrifice and move on in the hope that we could finish a syllabus in any defined period of time. Now, suddenly, Article 200 seems to become a very big fault line in the federal relationship. And we have never really applied our mind to what is an Article 200 principle really here. And the court is placed in a similar position and not doing too well. Let me move then to the biggest part, I think, of the federalism tussle that we are placed in today, which is on the fiscal federalism part of the story. The 16th Finance Commission is in place. The GST regime has come in. We have huge problems with the the cesses that are placed outside the GST regime, and we have huge problems with the distribution formula between the states. All this we know, and we usually teach this as an executive federalism problem. And lo and behold, it's in court. And it's in court in new ways. You know, I mean, whether one reads the older Basu texts or whether one reads comparative federalism text, we are always told fiscal federalism is an executive matter. It's not a judicial matter. And we now are working through this question judicially in at least 2 or 3 ways, and I'll just mention that briefly. The first is the mines and minerals cases, which are before a very large bench. It's a traditional case. It's about entry 50 of list 2 and entry 54 of list 1, and you know, all those old doctrines that we try and teach in class, arguments about eclipse and so on and so forth. But the numbers are huge. The amounts at stake are huge. And the stakes are high because we have frozen the GST regime and the sharing percentages on the other side. So the stakes are very high for the mineral-rich states because they're not going to get another version of how they might make this money because they've been denuded of their taxing power. So now they are left to tax in the interstitial powers in the Constitution. Hence, suddenly, entry 54 of list 1 looks like an ominous clause that denudes the state governments of taxing power. And all our old, you know, Keshoram Industries and all the other stuff that we've been teaching you for across the last 6 decades seem to require a new look, because post GST and post 15th Finance Commission, the question of taxing power is in a seriously new zone. We never thought that state borrowing power, Article 293, I think I was one of those boring teachers who kind of taught Article 293 in constitutional law classes and stuff, all this stuff about borrowing power and who could borrow and how, and why should the state get union consent and so on and so forth. We would discuss, you know, in a sort of 1990s kind of way and say that, oh, we would all end up like Latin America, where subnational entities have such high exposure to foreign debt, and so 293 and so on is critical. Now 293 is in court with the Kerala government challenging Article 293 and the compatibility of fiscal responsibility legislation to Article 293 with respect to borrowing power. This is all novel argument. These are all Article 131 cases. Now I'm going to try and conclude. I think I'm going over time already. I'll just conclude in a couple of minutes. So I'm trying to say that we are in the federalism story and dealing with a very new kind of a zone of litigation in the field. It's suddenly federalism has risen in salience in court litigation. Shadan has already alluded to the problem of political competition. But my short response to that is that the problem of partisanship and political competition is something that we anticipated even in the Article 356 cases. That part we knew. And my sense here today is that we are in a slightly different place. And I would just go to Kenneth Weir and in his old 1960s classic on modern constitution says something like this. He says that what protects the liberty of the people? He says rights protect the liberty of the people, and federalism protects the liberty of the people. And when we taught this was always taken to be some kind of quaint reference, look at Kenneth Weir talking about how federalism protects the liberty of the people. Federalism has nothing to do with liberty problems. And I take Shadan's kind of point about what's happening in Delhi and beyond to be sort of a reminder that suddenly federalism is not just about identity expression and it's not just about political partisanship. Federalism has taken a completely constitutionalist tone, by which I mean that constitutional sustenance might depend on the success of the federal arrangement, right? And I don't think that whatever heavy burdens we placed on federalism as a concept in Indian constitutional law, we ever imagined that it would work as a bulwark against this kind of political arrangement, that constitutionalism itself would depend on the success of federalism. And I think that's where we are. It's new territory, and it's worth all of us spending a lot more time thinking about it. Thank you, and back to you, Ram.
Thank you, Sudhir. I think you flagged some of the key themes that emerged in the last year and a taxonomy of the issues that are connected with all those cases. I think all of them are very significantly important, besides the big one, the 371 that we have been speaking about. Our last panelist for this particular discussion would be Snigdha Singh, who currently teaches in Christ University Central Campus in Bangalore. Snigdha.
Thank you so much, Professor Chauhan and the organizing team for inviting me and hosting all of us. We have gathered today to discuss developments in Indian federalism, particularly in the last 1 year. And most of the earlier speakers have spoken about the impact of different aspects of constitution in the form of cases. My approach will be slightly different. Both the cases that had been outlined in the concept note, NCT of Delhi versus Union of India and In Re, Article 370. Interestingly, both these judgments have different or opposite impact on Indian federalism, like as has been outlined. One furthers the principle and the other diminishes it. And there have been numerous developments in the last few years which have had considerable implications on constitutional jurisprudence. In my opinion, one of the most significant judgments which has serious repercussions on constitutional values and fundamental principles is In Re, Article 370. So we now also have a movie on Article 370. I don't know, within months of delivery of the judgment, also before elections. I'm yet to watch the movie. But I'm going to confine my discussion with certain aspects of 370 judgment and its impact on federal principle. It's not really possible to cover all, but I will pick 2 issues. But before I share my thoughts and concerns on the subject, I would like to keep us in mind the original idea of federalism, with which we began shaping our legal system. And I'm going to again, refer to the oft-quoted reply of B.R. Ambedkar in the Constituent Assembly, which was given on 25th November 1949. It was his response to criticism of over-centralization in the Constitution, which has also been referred to by the Supreme Court in the 370 judgment. He stated, and I quote, "A serious complaint has been made on the grounds that there is too much centralization and the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. The basic principle of federalism is that the legislative and executive authority is partitioned between the center and the states, not by the law to be made by the center, but by the Constitution itself. And this is exactly what the Constitution does. I won't read out the entire thing, but the last line is very, very important, which says, the center cannot by its own will alter the boundary of this partition, nor can the judiciary. End of quote. A lot has changed, like I said, over the years. Our political system has evolved. The Indian Constitution has undergone more than 100 constitutional amendments. But what has not changed, or perhaps should not change, is our fundamental understanding of constitutional essence. What cannot be disputed is the federal nature of Indian Constitution, even though unique in form, is a form of basic feature of the Indian Constitution. It has been reiterated by the Supreme Court time and again that federalism in Indian Constitution is not a matter of administrative convenience, but one of principle, the outcome of our own process and recognition of ground reality. People have spoken about the asymmetry in our system, and the horizontal asymmetry gives differential rights to different states. The state of Jammu and Kashmir was the only state to enjoy the right to have its own constitution and special treatment, temporary or permanent, in the form of Article 370. Now, with this in mind, I would like to briefly revisit what really happened in the case of Jammu and Kashmir. So Chief Minister Mehbooba Mufti resigned on 19th June 2018 upon the withdrawal of the BJP government in the state of Jammu and Kashmir from the alliance with Jammu and Kashmir People's Democratic Party. The governor issued the proclamation pursuant to Section 92 of State of Jammu and Kashmir and could not have been extended beyond 6 months. The governor dissolved the State Legislative Assembly on 21st June 2018. Proclamation under Article 356 of the Indian Constitution, before the end of that 6-month period, was issued on 19th December 2018. It was approved by both the houses of the parliament, without the governor's report apparently being placed before them. Approval of extension of precedent rule was given on 3rd July 2019. And when the proclamation was in force, the president issued 2 constitutional orders, in the form of 272 and 273, and the cumulative effect or impact of these 2 constitutional orders was to extend all the provisions of the Indian Constitution to the state of Jammu and Kashmir, and to do away, to abrogate the position or the special status of state of Jammu and Kashmir altogether. Consequently, Jammu and Kashmir Reorganization Bill was passed, which bifurcated the state of Jammu and Kashmir into Union Territory of Jammu and Kashmir with State Legislative Assembly and Union Territory of Ladakh without one. Now, abrogation of special status of Jammu and Kashmir was challenged by challenging the 2 constitutional orders, 272 and 273, and the proclamations issued by the governor and the president in 2018, extension of the presidential proclamation in 2019. Now, let us first look at the implication of using Article 3 to extinguish the status or the character of statehood. President had the power to extend, modify the applicability of certain provisions under Indian Constitution to the state of Jammu and Kashmir. And pursuant to this power, and as we all know, Article 3 gives power to the parliament to alter the boundaries, area, change the name of the state. The only requirement in the form of the proviso is that the opinion of the state legislature has to be obtained, which is not binding. So it's just the opinion that is to be sought, not the concurrence. A second proviso to Article 3 was added by the Constitutional Order 48 way back in 1952. In case of Jammu and Kashmir, which provided that no bill increasing or diminishing the area of state of Jammu and Kashmir or altering the name or boundary of that state can be introduced without the consent of the state legislative assembly, legislature of that particular state. Now, what really happened due to imposition of 356 is that this clause, second clause, which was applicable in case of state in Jammu and Kashmir, was done away with. So this was suspended through Constitutional Order 272 because Obviously, all the provisions of the Indian Constitution became applicable. That proviso which was applicable before was not applicable. A specific sort of provision was also included in the Constitutional Order 272. Now, naturally, there are two questions that arise. First is whether the reorganization of a state into union territories is permissible under Article 3 generally. And the court has left this question open in general. The court has not answered this question. In reference to state of Jammu and Kashmir, this was not answered on the assurance given by Solicitor General of India that the statehood will be restored in that part of state of Jammu, Union Territory of Jammu and Kashmir, which has a state legislative assembly. And recently, Justice Narman, in one of his speeches, had mentioned that and it's very, very important for us to understand that will the assurances of Solicitor General of India be binding on the subsequent government? If it's not, then it is a big problem, because now the independence or autonomy of a particular state is left at the mercy of the center or the assurances of the Solicitor General. The other part, the autonomy of the other part which provided the power to the parliament to convert, it was accepted in the court. The parliament had the power to create a union territory out of the state, and therefore the question of Ladakh was settled. The only question with respect to union territory of Jammu and Kashmir was given effect to on the basis of Solicitor General's assurance. The second question, which is very important in reference to this case, is could the parliament have substituted its own views for the views of the state legislature as required under proviso to Article 3 in the view of power conferred by it under proclamation issued under Article 356? So here you have, so even if you suspend the second proviso to Article 3, which was made applicable to state of Jammu and Kashmir, the proviso still remains applicable, which requires the views of the state legislature. The president referred the reorganization bill to the Lok Sabha and Rajya Sabha for their views, since the parliament exercised the power of the legislature of the state in case of Jammu and Kashmir in the view of proclamation. In effect, the parliament consulted itself before bifurcating a full-fledged state, having a special position to the extent of having its own constitution, into two union territories. And the court has held that the views expressed by state legislature under proviso to Article 3 are not binding. And reference was made, or reliance was placed on Babulal Parakhe versus State of Bombay. And therefore, Parliament's exercise of power under the first proviso to Article 3 was considered to be was considered to be valid and not malified, or not made on malified grounds. Position with respect to states' consent was, like I said, long settled. Concurrence was not required even before, but healthy constitutional conventions prevented its misuse to a great extent. Rest assured, this move of converting a state into two union territories is unprecedented. It has never happened in the history of India. And most of the prominent scholars like H.M. Sirvai, in a way, defended the federal nature of Indian Constitution by observing that even Article 3, which was anti-federal in form, had never been, was not anti-federal in spirit, because Parliament had never unilaterally, on its own volition, kind of initiated the process of bifurcation of a particular state. It was always at the behest, most often at the behest of the states. And this observation was way back. So that's a reference. It's been given in his book, and it has been quoted in S.R. Bomai versus Union of India. What was underlined in Vere's judgment is that this anti-federal feature was to be used in exceptional situation, which allows the parliament to alter the boundaries of a state using ordinary law passed by a simple majority vote. Right? It's not the procedure that is to be followed under Article 368. And the conception of the Union of India that we had, India that is Bharat, that is Union of State, is an indestructible union of destructible states. And as opposed to the position in other federal systems where it's an indestructible union of indestructible states, there was no territorial integrity accorded to the states in India, but it had a different sort of reason. Like Sudhir sir had already pointed out, the original demarcation between Part A, Part B, and Part C states had colonial idea. It was the colonial demarcation, and that is why they were placed in 3 different categories. Consequently, a 4th category was also created. But we wanted to, upon getting our independence, we wanted to redraw our boundaries on some indigenous rational basis, and then, consequently classify the constituent federal units into more, into states and union territories. It was not done to structurally place union or center above the state. And that is why I refer to the opinion of the speech of B.R. Ambedkar in the Constituent Assembly, because it goes back to the original idea that we have. Even with the centralizing tendencies, there was never a doubt that the states and the center were co-equals. One was not above the other. The court, by using Article 3 in such an unprecedented, giving such an interpretation to Article 3 by not really answering the question whether a particular state can be converted into 2 union territories or not, because it said it will be taken up in the future cases. By doing this, the court has really set a very dangerous precedent. Literally, it has given a free pass to the center to destroy the autonomy of a particular state by just using Article 356, no questions asked. I also wanted to give reference to Article 356, but I guess I do not have time. But I will leave you on this last bit of thought that, Supreme Court, perhaps in my opinion, could have limited the ratio of the facts to this particular case, like it has done in various other cases, like D.S. Nakara versus Union of India. But what is also to be remembered is that the Supreme Court is not only the guardian of the Indian Constitution, but also the institution of last resort for rectifying the constitutional imbalance sought to be created through legislative and executive action. And therefore, the position taken, especially in a reference to Article 370 case, is a cause of great concern and has a heavy bearing on constitutional principles of federalism and democracy. Thank you.
Thank you, Snigdha, for very detailed insight into the 370 case. That squares up our panelist presentations. We heard a broader perspective on the role of the court, or the changing view of the court on federalism as such, and a critical perspective of that. We have also seen the way the Delhi and the contrasting the 370 case scenarios and the interpretations of it. That leads further to this whole Shadan's question of free and fair elections and the whole question of fairness as an important aspect. And we then heard from Sudhir, putting very briefly what all came up. So I think Sudhir did one theorization related to the difference between a state to UT to state differentiation, and the new situation that 370 has thrown open, the role of governor and the governor's office, and then the fiscal federalism question that is raised. And finally, Snigdha's detailed insight into the 370 and this whole question of the way the court's interpretation and the problematic nature of it is what we heard. So without much ado, so let me open the floor. We take one round of questions. I think we managed to put some decent 20-25 minutes time available for questions. So we'll take one round and then we'll complete. And if there is space, we will come back for the second round. So maybe about 6 to 7 questions in the first round. May I? Okay, Eamon, please go ahead. So.
Thank you all panelists. I also work on Nalsar's annual survey of state laws, which is a publication that covers the legislative work that states do. And one thing that we have observed in the 2 publications that we've made is that circumvention of state powers and federalism not just happens at, in a center state level in the legislative or the constitutional sense, but through practice. So year after year, every state is required to amend its FRBM acts because, fiscal federalism is under stress. they're required to amend their GST acts because, some entry was incorrectly made and that kind of thing. And of course, in 2020, we had the whole instance of the union literally acting like the World Bank and saying that you will reform certain administrative practices in your own states in order for us to allow you to borrow more. I think that reflects a broader trend than just constitutional relations, which, do turn up in court. But for years and years, this has been on that the union government dictates things to states that effectively renders Schedule 7 sort of pointless in its nature. So I just wanted Alok's opinion on it and Sudhir's intervention on the same.
Okay, thank you.
My first question is to Mr. Shadan, and the other question is for Professor Sudhir. Mr. Shadan, you briefly underscored the idea of courts policing the aggressive executive. It has been a trend that whenever the governments in power are the majority governments, it is a characteristic of the executives to be aggressive. Given this scenario, do you think the courts in India have the wherewithal that gives them the confidence to police actually the executive? My second question to Professor is about fiscal federalism. We see that constantly the fiscal federalism being questioned by states, because many a times we have seen the state center dictating the terms to the state. Same is the case when it comes to the relationship between Panchayati Raj institutions and the states. So would the court, assuming that starts accepting the ideal scenario of fiscal federalism in India, would the court be willing to walk the same line? And do they have the wherewithal to walk the same line when it comes to so many states and their relationships with the Panchayati Raj institutions? Thank you.
Thank you.
So my question is to Dr. Sudhir, but all the panelists are free to answer. Though it doesn't deal with the cases that we discuss right now, but I think it's very important as it pertains to tensions between federalism and the principle of one vote must be of the same value. Each vote must be of the same value. As we know, the delimitation exercise is long overdue, but would substantially take away power and importance of southern states and reduce essentially as to the dominance of Hindi heartland states. So, but at the same time, it's wrong that a Tamil Nadu person's vote values far more than a person living in Bihar per se. So, is somehow how do we deal with this tension? Is somehow another part of that question is somehow strengthening or reforming the Council of States, that is Rajya Sabha, the house which is supposed to represent the interests of states, can be a solution, maybe something like US Senate or something like that. So that's all.
Thank you.
Hi. So my question is specifically to Ms. Snigdha, but others can also answer if they want. And it is specifically on Article 356, as you rightly mentioned, the role it played in the entire Jammu and Kashmir saga. Had it not been for the imposition of president's rule there, everything else that followed could not have happened the way it happened. And now with the Supreme Court stamp of approval and basically saying that irrevocable changes can be made to a state by imposing president's rule there. And one thing that I've always found very strange about Article 356 is that it enables the union government to intervene if a state government machinery is not functioning according to the constitution. But what is the remedy when it's the union government's machinery which is not which is not acting as per the constitution? It's not like all the states can come together, overthrow the union government and take it over. So there may have been specific circumstances at the time when the constitution was being drafted why a power like this was required. But do we still need it in the constitution? Has the time come to retire Article 356 is my question.
Thank you.
Alok, sir, you mentioned that if the similar issue like that of J&K comes across states concerning like Nagaland, Mizoram, as compared from Madhya Pradesh or Telangana, for instance, it would attract a similar response from Supreme Court like they did in J&K. But in contrast to, because they are considered periphery states in India, but in contrast to this, in our constitutional law 2 course, we studied Louise Deline and how she argues that asymmetric federalism has worked well in northeastern states like sixth schedule, examples like sixth schedule, because they are considered periphery to the Union of India. Like, I would want to hear your take on that.
Okay, thank you. Could we move this side? Any hands this side? Okay, here. We'll finish. This is the last question. Yeah.
Hello, panelists. Thank you so much for what you said. My question is a little related to the topic, but a little different. I want to. Actually, there's very less attention being paid to the case of Ladakh and how it's demanding the sixth schedule status. Now, originally, our understanding has been that it's only for those three northeastern states. I just want a comment from any of the panelists. Is sixth schedule a possible solution for Ladakh? Is it even possible for Ladakh to be included in the sixth schedule, or was it originally just an idea meant for those three very particular states? Any comment would be great. Thank you.
We'll follow. Thank you. We'll follow the same order in terms of responses. So we'll begin with Alok.
Okay. Can you all hear me? Yeah. Okay. I think on the question of fiscal federalism, there's two elements to it which I think it's going to be in constant tension. One aspect of it is that the states kind of have not been the most responsible when it comes to spending. There is a certain sense of, I won't exactly say irresponsibility, but a sense of it's not my problem really. It's not like one particular state can go bankrupt in India, really speaking, constitutionally speaking, because at the end of the day, the union government is backstopping all the states, right? So there is that one tension. And the other tension is, I want to be able to do a lot of things, which state governments do. I think the bulk of governance in India actually happens at the state government level. It should happen much more at the local government level, which is a point that someone also raised. I'll come to that. But I think these two things are in tension right now. And one thing, an element that I want to bring that isn't being talked about so much is states have kind of allowed their taxation muscles to atrophy. GST hasn't taken away your power to levy professional tax. And this is something that we had recommended to the Finance Commission in the 14th Finance Commission. We had said, ask the union to remove the cap on professional tax, because this is a ready and easily collectible source of income for states. Pakistan has done it. Pakistan has removed the cap. It's like some 25,000 rupees or 50,000 rupees in Pakistan. Now in India, it's a ridiculously low 2,500 rupees per person per year. And it's not worth most of the states to collect it, right? Even though some of the states that are collecting it are not doing such a great job. Be that as it may, they are not improving their tax collection efforts or trying to find ways to raise more revenue more efficiently. Even in the context of property tax, they have to be dragged kicking and screaming into undertaking property tax reforms, which will allow municipalities to be more efficient in their collection. Second thing is a great avenue has been opened up in the Mohit Minerals case. Now, I have a problem with the Mohit Minerals case. That's a different issue. Mohit Minerals case, the Supreme Court has said that the GST amendment did not bar states from passing their own law to levy GST. And it basically said that the GST recommendations are not binding. Which state has said, thanks, we'll pass our own law as well. Because they know they have to do the hard work then of revitalizing their tax collection measures. They can't rely on the same GSTN network to collect their taxes and distribute to them. They will have to make additional efforts to set up their own tax bureaucracy and find a way to collect their taxes and so on. And they've kind of chosen not to so far. If states had been perhaps more keen on levying taxes and finding them struck down in courts, I would have had much more sympathy for them on the fiscal federalism aspect. if I have to use like a personal metaphor, you want to eat sugar 3 times a day, you don't want to exercise, and you're wondering why is my body such a weak shape? Which I think, and that, of course, you will complain to the person who is sort of making you do more work, saying, hey, I don't want to do this much work. But I would still say the states do have a responsibility under our constitution to also try and be as within the powers of the constitution. I'm not asking you to violate the constitution to do some of this. They're not doing some of this on their own. There was a question also, I think, on which comes. I'll address that point, which is also made about fiscal federalism in the municipalities and the panchayats context. I think we should use this term fractal federalism for our country. Whatever relationship that happens between the union and the state replicates in the context of municipalities and panchayati raj institutions. If the center is pulling away resources from the state is equally pulling away the resources from the municipalities and panchayats. There is a great book by my namesake V.N. Alok on state finance commissions and how money is being sent from the state to the subnational, to the municipal level. And it kind of shows you how badly states have fared in this, right? While we know that there is a well-functioning, maybe agree sometimes, disagree sometimes, Union Finance Commission, a lot of states haven't even set up finance commissions properly. They didn't set it up on time. They don't give them clear terms of reference, and they ignore most of their recommendations. So on the one hand, you want federalism vis-a-vis the union, but vis-a-vis panchayats and municipalities, you're like, no thanks, we will only run the whole show. On the last couple of questions, I will very quickly address. Maybe Louise will have to rework her work. Because I used to think the same way, but after having read these two judgments, I think the Supreme Court has, like the provisions, and this has occurred to me when I was presenting this paper at a different conference. We have seen 370 to 371J as one whole system of asymmetric federalism. Maybe there are actually two systems there. There may be those provisions which are intended to integrate parts of India which were not very keen on being Indian. I'm talking about active violent insurgencies which broke out in places like Mizoram, in places like Nagaland, and places like Manipur, which were like, we don't think the deal we're getting from the Indian Union is that great that we need to stay with you guys. And the deal had to be changed for them. As opposed to say maybe giving Telangana more power over the government servants it hires, or creating a special fund for the quote-unquote Kalyan Karnataka part of Karnataka. Maybe those are slightly different arrangements which are intended purely politically to address a certain political concern. Right? I don't want to trivially dismiss them as saying, yeah, this is just for politics. Politics is important, which is why we're all here. Maybe there are actually, and this is perhaps where Luis may have to rethink a little bit of that asymmetric part. The consequence of this, the consequence of the 370 judgment to me seems to be that there is asymmetrical federalism and then there is asymmetrical federalism. One of which the Supreme Court will gladly uphold, the other of which the Supreme Court may subordinate to needs of quote-unquote national integration. So perhaps that may have what is changed. With Ladakh, I don't want to second guess a political demand, but may not be the most appropriate one, because at the end of the day, sixth schedule depends on empowering a governor, right? The sixth schedule was a mechanism which was worked out specifically because Northeast communities, and it's along with the fifth schedule as well, you have empowered a governor to be able to override democratic majoritarian impulses in these states. So in that context, I get the demand. I'm not so sure just replicating the sixth schedule for Ladakh may be the best option. I would say, like, you might want a greater devolution of powers. You might want a model akin to Delhi or Pondicherry or somewhere. If the concern is that we are now being run remotely by an even more remote government than we thought in the past, the solution is not just like add a couple of more rules. The solution may be to rethink exactly how Ladakh should be run to prioritize the needs and the requirements of Ladakhis. Oh yeah, sorry. And also Article 356. I think that's what the emergency provision is for. If constitutional government is not possible for some reason at the union level, well, one is, of course, that you can't form the government, president has to call fresh elections, right? Yeah, I suppose you're not talking about just a fact that no party has a majority, no one is able to win elections. And we have seen that happen. The prime minister resigns, fresh elections are called. That is not the situation. But if we are talking about some kind of total, complete constitutional breakdown, the only situation I can imagine is like this massive national insurgency of some kind or complete breakdown of government in the face of foreign invasion. That's what the emergency power is for, right? I would say that is what it is for. I mean, and 356 is an emergency power. It's an emergency power, but applied in the context of one state. But if it is a quote unquote national emergency, that's what the emergency power there.
Yeah, I'll quickly try to address three of the questions. So the first question was, does the court have the wherewithal to do it? So our experience has been that in moments of pressure, our court's record is not exactly stellar. I mean, that's quite to be seen. But the real question to be asked is, I mean, rights are to be protected when they are under attack, right? There's no point of having the rights when they're not being attacked. In terms of the court's role comes into play when there is a question mark. So I think the most important role for the court comes when it is being asked upon to do its work. And I would look at it from that perspective. Does our history offer us a lot of hope? Our history on that aspect is, I think, a mixed bag. So there are some good moments, there are some bad moments, and I think we survive on hope on that count. Second was the Article 356 question, that it's really gone out now in that sense. And that's right. I mean, the last use of 356, which was, I mean, it was 360. I think it was 356 was 2018 Karnataka.
Yeah.
Yeah, it was. And that the court intervened very quickly, the Supreme Court. They called out, I think, within a matter of 3 or 4 days. I mean, that's the kind of intervention which makes the difference, right? Like if you do it that quickly, the chance of misuse is almost eliminated. So 356 is out. But what's happened now and is that, like Nizam was saying in the first, this thing, everything can be weaponized. This is a pen. Everybody has thought about, write refill, ink, this, that. Now somebody thinks I can stab somebody in the stomach with this. It's a weapon. This is a microphone. Everybody's thought about volume, this, that, other. Suddenly I think, oh, this is very heavy, the bottom of it. I can hit somebody on the head and kill that person. I can smash this glass in somebody's face. So you can literally weaponize anything. And that's the kind of thing we are seeing now. There's no protection against that. It's not a question of architecture, right? So 356 is gone, but a whole set of other things are being used. And I sort of litigate that regularly on a daily basis. And every day I get surprised. Oh, this can also be done. And like, what's the answer to that? So I think the answer, that's why the court's role is very important. And finally on Ladakh. So my understanding is the present demand is for something like a statehood. But I mean, the idea is that, of course, the Ladakhis were unhappy with the JNK setup because they were treated as periphery within the JNK setup. And they were very happy when this 370 move happened. Initially, there was, I think, a lot of welcome of the move within Ladakh. But over a period of time, they have realized that this is actually even worse than what they had, which they anyways resented. So now we have a situation where they are looking at something. My sense always is that I think the classic Indian state model is the best model. It actually gives you enough because all these other formulations, it leaves enough for the center to intervene. And having litigated in Delhi every day, I mean, those openings are enough for anybody who wants to continuously intervene. And we've had a whole lot of border states which are full-fledged states. That's the history of this country. So it's never a national security issue, right? You have all kinds of border states from Arunachal, which are full-fledged states, right? Gujarat, Rajasthan, Punjab. So I think the classic state model make Ladakh a state. And I think that should sort out the kind of democratic demands which are there. So those are the three questions that I addressed. Thanks.
Yeah, thank you. Sudhir?
Yeah, thanks, Ram. So first and foremost, let me just congratulate the audience because these are fantastic questions, almost every one of them. And I'm going to try and be brief and glad to take any clarifications in response. The first was about state laws and whether Schedule 7 division is no longer relevant because of the possibility of conditionalities. I'm going to take it that was the provocation. So there was a view in the 1990s that federalism should move away from legislative conflict, kind of list 1, list 2, list 3 conflict to a sort of federalism by contract, that states should come together, form consensual agreements inter se among states and between the states and the union and sort of de-juridify the federal space. The contracts move is what the conditionalities model is about, right? And now the sense that that's time was that this kind of federalism by contract is a more benign model. It's better than people fighting it out in courts on a juridical model. Today, when one looks at the Article 293 petition by Kerala and so on, and the complaints from the state of Karnataka, among others, the federalism by contract type model is under serious pressure. And it seems now that federalism by contract is more onerous than federalism by legislation. So it's a sort of a fundamental root and branch rethink. I don't have a smart answer to what is the better model, except to say that the sort of intuitions of the late 90s, early 2000s have not worked out so well as we look at it in 2024. On the fiscal federalism question and point, so we, in a multi-level government system where you have the union, you have the states, you have local government, and maybe sometimes some things in between, so you have multi-level government, it would be a mistake to assume that the same principles apply at all levels. That is, that the federal principle which applies between the center and the states, or it should apply, or an equivalent should apply between the states and the local government. In any case, our court is far less than articulating a principle about the relationship between the states and local government. They've barely managed to understand that now it is a constitutionalized relationship. They treat it still as a statutory relationship with really all the powers with the state government. So we are at a very early stage, but on your very provocative question, what do you do with state finance commissions? I, for one, would go with Alok that the states get shown up badly because the very same states that argue for a stronger center state distribution have a rather poor track record of state local government distribution. Kerala is probably the counter example, but barring Kerala, the other states are not looking too good at this point. The question about one person, one vote and bicameralism is a fantastic question. And frankly, I haven't thought about bicameralism as a check on the one person, one vote delimitation exercise problem. I haven't thought about that at length. But let me say two things by way of response. First, that one person, one vote, we don't generally see as a federalism problem at all. We see it as a problem of democratic representation. What is the right way to do constituency level delimitation? Bicameralism we've always thought of as a solution to a federal identity problem, and we have institutions designed for that. Can one act as a check on the other? And I take it that your intuition is that the US-style Senate, which has a non-representative number, say 2 per state, which is not a delimitation-based number, should constitute the upper house. That's a very interesting thought, and the history of the United States has some lessons on this count. They were dealing with a similar problem, they thought, in that time. The disenfranchisement of some states was the motivation for the Senate rule. So the Senate amendment, sorry. So I think there's something to think about. So thank you for that question. And it's a very promising line of inquiry. I'll combine the last two comments about Nagaland versus Telangana and the Ladakh question into one point of response. And the way I look at it, and I don't disagree with Alok's response that Louise Tillon might write another book were she to look at the issue today. But my sense here is that we have to think about how we look at historical evolution of constitutional arrangements under contingent political circumstances, and what principled lessons can we draw. For example, when we say sixth schedule is for the northeastern states and so on, and with Alok's caution that it simply empowers the governor, I don't think that we should limit the evolution of a constitutional form to its contingent political history of its evolution, right? It evolves in a particular context, but it can travel. So generally speaking, I think we need to bring a more principled understanding to the question of asymmetry and the question of fifth and sixth schedule generally, we haven't done that. We have seen it as a realpolitik problem, which is that if there's mass riots and ethnic violence, you do something. But can we take a more principled, conceptual view of that problem? I think it's possible and productive. While I'm at it, Ram, I have a question, and I have a question, if I might just throw it in for the other panelists and anyone in the audience, frankly, who wants to jump in, which is about the sudden re-emergence of the Article 131 original suit as a form of litigation on the federal problem. Now, it's not that it's a new article. It's existed, was litigated heavily in the 1950s as well, but then went quiet. But suddenly we see the possibility that I can litigate the CAA on Article 131 suit. I can litigate fiscal restrictions on Article 131 suit. Now, I'm going to assume that the range now is pretty limitless, because should the court be willing to concede the jurisdiction to a range of matters. This is altogether new territory, and I'm curious if anyone in the panel or audience might want to jump in on that. Back to you, Ram.
Yeah, thanks, Sudhir, but we'll hold for the moment. Let Srikta complete the response and then.
I think it's a brilliant question, the question that you asked, whether the time has come to end Article 356. And you cannot really answer this question without going to the reason as to why it was introduced in the first place. So emergency provisions, along with centralizing tendency, if you refer to the objective resolution, the idea was we'll have classic sort of original form of federation with the residuary power being given to the states. And it was only on account of reasons when partition was announced, and we were supposed to have belligerent states, both in the form of East Pakistan and West Pakistan, threat from the side of China, and then there was vociferous tendencies, secessionist tendencies, and therefore the integrity and unity of the India was given primacy. And a number of provisions were included, including the emergency provision, which were to be exercised only in exceptional situation. And I'm relying on Sarkaria Commission report, which stated that, most of the provisions in Indian constitution, which are provided de jure as practice de facto in other countries, in other federal countries. And so is the case in Indian Federation, but we have put it in writing in the form of constitutional provisions, because we were not sure if the constitutional conventions would work. As it is, most of the constitutional conventions from UK have been incorporated in the form of constitutional provision. I believe that federalism is more a functional approach than a structural approach. It's not my original idea again, but I don't remember where I'd read it. But if the functional approach fails, then probably we need to rethink. And again, we can have reference to the way it was utilized in the case of the state of Jammu and Kashmir, because when the question was actually asked, the court did acknowledge that we are not going to go into the validity of imposition of section 356, because what was really argued is the consequence or the actions taken pursuant to imposition of 356. Though it did acknowledge that laches and challenging the proclamation cannot by itself be a valid ground to reject a constitutional challenge to the proclamation under Article 356 or section 92. And it said that we can't have a very strict standard of scrutiny to, on a case-to-case basis, look at all the actions that have been taken by the union government during the proclamation of emergency, because the system is going to correct itself. There is a quote I would like to quote from the judgment. It says, the political process can correct itself, and any difference that have arisen between the democratic will of the people exercised through the elected representatives in the state and the decisions taken by the president in the parliament can be ironed out upon a return to normalcy. For these reasons, we do not believe that the court ought to sit in appeal over every decision taken by the president during the imposition of Article 356. And this is after the safeguards that have been introduced by Sarkaria Commission report, which have been endorsed by Supreme Court in S.R. Bommai case. What really happened is, the governor, the court, one second. It was argued in the case that, when the support was actually withdrawn by the BJP government, there were opportunity form alternative government was not given. That's a categorical instruction, Sarkara Commission report. So there was no chance to return to the federal normalcy, which is the way federation operate. Again, the governor reports were not placed or considered in the parliament before proving the imposition, or the state legislative, before dissolving the state legislative assembly, the president rule was not approved by the parliament. So if this is the way the court is going to function, we need to rethink whether 356 needs to be there in the interest of constitutional principle of federalism.
Yeah, thank you. Anyone would like to take for half a minute the 131? Yeah.
Yeah, that's actually, I'll try to answer that. I think broadly, even historically, the power has been used. The plaintiffs in those suits have always been states. I don't think union has ever come into that jurisdiction as a plaintiff. So normally the party which is being wronged or claims to be wronged at least is the state. And you're absolutely right, Sudhir, that it did in the middle stop. And now we are seeing a very massive resurgence. In fact, for the state of Punjab, I am dealing with 3 or 4 suits against the union right now. I think the reason is that, of course, there is a deadlock of communication or hardening of positions. And I don't think it is being resolved at in an informal federal, cooperative federalism kind of a way. So that's not happening. Then what remedy do the states have? They have to come in a 131. And 131, the language is pretty broad. Any question of law or fact. So it's effectively like an original court, right? So anything under the sun really can be brought under it in terms of, a creative lawyer will not find it too difficult to bring any dispute within the realm of 131. And I think third thing which has happened now is, and this is a matter of procedure, we see quite regularly in 131. If you tell the judges that there's no evidence to be led, it's as fast as a regular 32 or a SLP. So you come in because it's not, the problem with that suit was that, oh, will evidence, the procedure, pleadings, that takes 5 years. My suit will be dead by the time my government will be out. What am I really coming for, right? So now that is gone. You are actually getting within a year to year and a half of the filing, a final hearing. And if with that, it's as good as any other remedy. It's exclusive remedy if it's a state versus union. You can't go to any other jurisdiction. You can craft pretty much any dispute within it. And there is a hardening of positions. I think all those 4 factors are leading to this sudden surge of 131 suits.
Just to add one final bit of what Shadan is saying. In the middle, and I remember this in my few years of practice in the Supreme Court when I was a government counsel, states used to file a lot of 131s against each other. There would be there wouldn't be big issues which would capture a lot of discussion. I was just mentioning it to somebody just over lunch. Bihar and Jharkhand were locked in a years-long battle over who owns Bihar Bhavan in the in Delhi. And it was an interpretation of the Reorganization Act. You have to go into the history of how the Bihar Bhavan was set up. Long standing, long pending, and every time the case came up, the judges would be like, really, this is what you're fighting over? But there were quite a few of those pending, I guess. Now, increasingly, for all the reasons Shadan has pointed out, and as you rightly pointed out, the cases against the union by the states have probably increased far more than they were in the past.
All right. I thank all the panelists. So I'm sure you would agree with me that we had one of the most energizing and insightful post-lunch discussion on a bland subject like federalism, certainly. I'm sure, I suppose we all know that federalism is under stress, but I think you would agree with me that we are at the end of this panel discussion or better equipped in understanding the nature of that stress to a reasonable extent. And further to that, I'm also adding a particular point that Sudhir said, that, if we are serious about protecting our individual liberty, perhaps an important part of sustaining it would be, looking at federalism, strengthening it in the most robust way as possible, and without which maybe the liberty itself is at stake. Not just only the state-center relations, but something more fundamentally about the liberty itself. I think these are very interesting points. I'm sure they're leaving us with more questions and more energy to really engage with federalism question under the Indian constitutionalism. I think that's a good way of putting a pause to this particular framework. So may I ask you to give a big hand to our panelists for a wonderful discussion.
Thank you.
I'm taking liberty to say on behalf of the organizers, let's try and cut short the tea for by about 10, 15 minutes or so that we can start ASAP possible for the next session. Yeah, thank
I
you.
request Sitaram sir to give a token of our appreciation to the esteemed guests, starting with Alok.
See, I think this.
And to Shadan Fayasat. And to Professor Snigdha. We'll send one.
Sudhir, you will receive by post.
Thank you, everyone. The tea is served near the Thinking Man. The next panel will start at 4:45. We'll try to start it on time. Yes. Thank you.
Hello? Sir, can you hear us?
Yes, I can hear you.
Nalsar, can you hear us?
Hello? Yes, I can hear you. Do you hear me?
Yes, sir. Thank you.
Thank you so much.
Yes.
Good afternoon, everyone. I welcome you to this panel on socioeconomic rights in the specific context of the SAARC countries. So we have speakers from Pakistan and we have speakers from Colombo, Sri Lanka. So can I request the speakers from outside the country to go first so that we have a sense of where we are dealing with, and also welcome Justice Sapna Pradhan for sitting in on this conversation. And I hope that she will have interventions to make, given that this is in the specific context of the SAARC region. Can I invite speakers from Justice Syed Mansoor Ali Shah to go first, and then can we have Niran to go later, and then we'll have Justice Bhatt to come in. Is that all right with both of you?
Yeah, that's fine. That's fine.
Sure.
Thank you so much.
Yes, sir. So
Yeah, thank you so much. Yes, sorry.
Sure. I thought I'll just make a couple of preliminary remarks before I hand over the mic to you. The context of socioeconomic rights and to discuss this in the SAARC region has a special significance. Since morning, we have been looking at most largely structural issues. So we've looked at questions of federalism, we've looked at questions of electoral democracy, and from that, we are moving to a question of socioeconomic rights. Looking at socioeconomic rights in this context is also very significant, given that usually when we refer to rights not as a structural question, and we refer to rights as largely individual, or we refer to rights in the context of a liberal state. And we're looking at individual rights against the state. But the specific context of socioeconomic rights is important, given that in the SAARC region, from the beginning, these regions have given a lot of importance to the question of socioeconomic rights. with some constitutions writing it into their constitution. The Indian constitution also for a long time, the DPSPs, although they were written in by the framers of the constitution, intending this to be a charter for governments, was not viewed by the Supreme Court for a long time as a charter for governance because they were not enforceable, non-justiciable rights. And that is a legacy that we have fought for a long time. And today the Supreme Court is perhaps more amenable to accepting socioeconomic rights as justiciable rights, but they come with their own set of difficulties, right? Because they are largely also seen as policy questions. They're also seen as questions where it becomes difficult for courts to enforce their own rulings. But I think the Indian Supreme Court has set a very good example, whether in context of the PILs, which led to several issues, whether of addressing famine, addressing the right to food, or addressing the whole question of the recent judgment with reference to manual scavenging. We are seeing that the courts, despite not having enumerated rights as such with reference to socioeconomic rights, have still found a way. But it always raises the spectrum of judicial activism. It always raises the idea that is the judiciary overstepping its bounds when it gives these orders to the executive and the legislature. So it's very apt that we have two judges, one, of course, a former judge of the Indian High Court and a sitting judge of the Pakistan High Court and a sitting judge of the Nepal High Court to give us insights on how the judiciary views its role with reference to socioeconomic rights. And then, of course, we have a perspective coming in from Sri Lanka and from an academic to tell us about how, particularly in the SAARC region, the socioeconomic rights assume a very different context as against several other jurisdictions. With these few words, may I invite Justice Syed Mansoor Ali Shah, Judge, Supreme Court of Pakistan, to address us. Sir, you have 15 minutes. And then we will open it up to the other panelists, and then we will have questions.
Thank you very much. Thank you, Nalsar, for inviting me to this talk. What I plan to do is to showcase some of the jurisprudence that has come out of Pakistan and how Supreme Court is dealing with these rights. But at the very outset, let me say that we at the Constitutional Court don't have much of a division between socioeconomic rights and the civil and political rights. We would probably amalgamate together all these rights under a heading called the fundamental rights or the human rights as such, because we find there's a deep intersection between both sets of rights. They complement each other. So the constitutional courts have been taking them as fundamental rights, and if you look deeper into them, you would find some socioeconomic rights, or you would find civil and political rights within that. So as an amalgamation of both, we would consider that as fundamental rights or human rights. And in that context, would I like to explain how our court has progressed over the years in advancing these rights, enhancing them, progressively interpreting them. So the tools that the Constitutional Court has used, there are three rights out of the fundamental rights which have been most significant throughout for the last decade maybe, has been the right to dignity, which is now of late come out to be the major right which is really driving most of our jurisprudence. The other is right to equality, of course, and right to life and liberty under the Constitution. So amongst these fundamental rights, I would like to underline that the right to dignity stands at the top, like a jewel in the crown of fundamental rights. So it is the courthouse that ultimately projects and preserves the rule of law, individual freedoms, human dignity, minority rights, tolerance, and social justice. We also just point out that how are we looking at democracy when we look at our Supreme Court, or how do we envisage this before we go into the rights? So right to vote or elections, political parties is a formal or official or procedural side of democracy to us. On a more substantive side, democracy is based on core and fundamental constitutional values like separation of powers, independence of judiciary, rule of law, and the human rights. What do we really mean by the rule of law in our context would be that, well, it is that king is no more the law is the king, which is fine. Rule of law at one level means rule of laws and not men. That's also to us a formal or official side of rule of law. because if that was the case, then Hitler and Stalin would also have rules, and those rules were to be followed. The deeper meaning that we attach to rule of law is that laws must have an inner core, laws that ensures liberty, individual freedom. Laws must always be in public interest to protect and preserve equality, tolerance, life and liberty, privacy, dignity, freedoms of thought, expression, belief, faith, and worship. So this inner core value has to be there for the rule of law that we're trying to promote to exist. So without the protection of the rights of people or human rights, there can be no democracy or no justification of democracy. I also want to highlight that one other power that the Supreme Court of Pakistan enjoys, which I'm quite sure I think India does have also, is the suo motu power, where the court could itself take up a matter if it thinks there's a matter of public importance and concerns the enforcement of fundamental rights. So this unique power that we enjoy, the court could really reach out to the depressed classes, the weak, and pull them up if the court so wishes. With that background, let me just now showcase some of cases coming out of Pakistan just to highlight some of the rights that we've robustly interpreted. One is the gender sensitivity approach, which cuts through the socioeconomic rights as well as civil political rights. So feminism is a social, political, and cultural movement that aims to establish and achieve equal rights, opportunities, and respect for women and girls. It seeks to address and challenge the systemic inequalities and discrimination that women face based on their gender. So over the course of time, courts of Pakistan, especially the Supreme Court, have been wearing a gender-sensitive lens, paving way towards a jurisprudence that's inclusive. This approach has been replicated in cases relating to two-finger test, that is the virginity testing case, the workplace harassment matter, and the property and inheritance rights of women, in particular in our culture and society, and the right to vote, etc., of women, which I'll just briefly go through. So in the two-finger test is a case to determine the impact of virginity testing in rape case. It has now been well settled by the Supreme Court that virginity testing in rape cases are irrelevant, and the tests conducted, that's a two-finger test, have no basis in medical science. Examination by the courts should be made only to determine the question whether or not the alleged victim was subjected to rape and not to determine her virginity or chastity. It was further observed by the court that in a criminal trial relating to rape, it is the accused who is on trial and not the victim. The courts should also discontinue the use of painfully intrusive and inappropriate expressions like habituated to sex, women of easy virtue, women of loose moral character, and non-virgin for the alleged rape victims, even if they find that the charge of rape is not proved against the accused. Such expressions are unconstitutional and illegal. Earlier, the High Court also had declared two-finger virginity testing as unconstitutional and held that the virginity test by its very nature is invasive and an infringement on the privacy of women to her body. It is a blatant violation of the dignity of a woman. Moving on the sexual harassment matters at the workplace, because that directly connects with employment law, the Supreme Court of Pakistan has held that harassment does not have to be sexual in nature under the national law, which is called the Workplace Harassment Act 2010. Any conduct that's rooted in gender-based discrimination and creates an abusive and hostile working environment is harassment under the Act, which is not restricted only to conduct that's related to the act of sex. Harassment covers all gender minorities, including transgender persons. It has also been held that the universal value of human dignity provides that all human beings are born free and equal in dignity and rights. It shuns patriarchy, misogyny, and the age-old archaic and dogmatic social norms, and nurtures progressive and forward-looking constitutional ideals of liberty, equality, and social justice. It is time, and I quote from the judgment, it is time to bid farewell to gender biases and prejudices and pave way towards actualization of these robust and unwavering constitutional ideals and values by embracing the participation of women in all spheres of life with honor and dignity. Just want to point out that demographically, Pakistan has almost 50% women in the population, but that's not so reflected at the workplace or other professions that we look at. So these judgments are paving way for women to come into that kind of a demographic split that the country enjoys. Looking at property rights for women, which relates to their economic rights also, is a woman is entitled to her property and it cannot be disposed of without her consent. In our rural areas, the brothers could get together after the death of the parents and transfer land to themselves, and depriving women who cannot approach court and suffer and are deprived of their entitlement to land. So many cases that have come before us, we've held that denying females their inheritance also undermines their economic independence, prevents a rise in their standard of living, and concentrates wealth in male descendants, which offends another three principles. That's the economic deprivation of women prevents their full participation in all affairs of life, which is a part of our principles of policy, which is another principle violated. Then the right to vote, you see. Article 25(3) of the Constitution allowed for special provisions to be made for the benefit of women as an exception to the general rule of equal treatment. Right to vote was a precious right. It was held by the Supreme Court that elections are contested on the basis of adult franchise. However, reserved seats have been introduced to enable certain categories of persons who may not otherwise be able to compete fairly, including women, peasants, workers, to be a part of these reserved seats. The framers of the Constitution, in their wisdom, inserted these provisions in the Constitution to weed out bias, prejudice, discrimination, unfairness, and to attain a just society. So the Supreme Court upheld these reserved seats in favor of women, in spite of the fact that women can also contest from general elections on a general seat, just to ensure and give meaning to Article 25(3), which is reverse discrimination. Under the employment category, women employment stems out from constitutional right to equality. Women are a vulnerable group that are more affected from the floods than men. And this is in the context of climate change and the recent floods that Pakistan has been hit with. And I'll just come to the climate change jurisprudence also. Should include women. There must be maternity and health care for women. So there is an increased need for female doctors, trainers, and caretakers to attend to health concerns. This was in particular in the context of floods. A matter had come up to the Supreme Court. There were devastating floods. 1/3 of the country was underwater in 2018. So in another case, the Article 25 itself, while the difference on the basis of sex can be created and maintained, it shall be done only in those cases where it operates favorably as a protective measure for and not against women and children. So this was just interpreting the right to non-discrimination, but in favor of women. As far as education is concerned, the court has also gone ahead plays an important role to promote knowledge and understanding of rural communities. And there too, the schools set up for women were encouraged. Moving on to the environmental jurisprudence, which seems to now have a large effect on our economy, our workplace, our businesses, because Pakistan is seriously hit by climate change. And our environmental jurisprudence of late has taken another color, and we call it the climate justice jurisprudence now, which affects multiple sectors, because Pakistan does not emit any greenhouse gases. It does, but it's not significant. Our major challenge is adaptation, and that adaptation is multi-sectoral. It cuts through several sectors: agriculture, irrigation, and you name it, and urban planning also. So this jurisprudence sort of has a cross-cutting effect. So while developing countries like Pakistan may not be primary contributors to climate change, acknowledging and confronting its fallout is indispensable, especially for combating the high risks posed by climate change. It is in this context that our courts have broadly interpreted fundamental rights to include right to climate justice. In a recent case, which is the Asghar Laghari case, which is now accepted slightly globally also, the court nominated climate justice as a successor to environmental justice. Climate justice, as the court envisioned it, adopted a human-centered approach. It linked human rights with development. it sought to safeguard the rights of vulnerable people and share the burdens and benefits of climate change and its impacts equitably and fairly. This was a case where an agriculturist had come to court saying that because of the global warming, his agriculture is going to he'll go out of business because there'll be droughts, so there'll be floods. And the Pakistan government had come up with a climate change policy which needs to be implemented and which was lying on the shelf and nothing was going on about it. The court interfered and started implementing the policy as the government had framed it. So a continuing mandamus was issued and about 60 to 70% of those targets were reached by the court intervention. The court also carved out a new soft principle of international law called in dubio pro natura, which in case of doubt, always protect nature. And it went on. In another case where a cement plant was being set up in a fragile zone, which was water sensitive, the said plant was, the court interfered and such a plant was stopped and they said you cannot further build on it because for no other reason but to give strength to the concept of climate justice, saying that it was not a climate resilient step to take. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. And in that case, the court employed the formula, the principle of in dubio pro natura to intervene and stop what they were doing. So taking into account Pakistan's vulnerability to climate change, the court in several cases, including a detailed mechanism for utilization of financial support coming to Pakistan from loss and damage fund in the future. So the court has also gone ahead and started looking at the climate fund because this money is going to come, but the court is very sensitive about the fact that the money must go to the actual recipients who are going to be suffering at the hands of climate change and not otherwise. In cases involving developmental schemes, like any urban development going on in our major cities, the courts have disallowed any conversion of residential properties for commercial usage, which may have any environmental impacts, and illustrated the interplay of climate change in urban planning and design. It has urged development authorities to ensure to factor in adaptation, climate resiliency, and sustainability into their plans, policies, and decisions in order to protect constitutional rights. That's another step in the context of climate change. And then recently, while interpreting customs matter, the court introduced and protected the climate by saying that climate protection has also been seen in cases involving customs and taxation, while dealing with the federal government exemption on customs duty with regards to hybrid electric vehicles. The court, while upholding a uniform application of such exemption on new and old, small and large batteries, fully and partly hybrid cars, weighed in on the reason for such SRO being climate protected. The courts have also recognized principles of sustainable development, precautionary principle, public trust doctrine, inter and intra-generational equity, and water justice, food justice in the context of climate justice. In the context of minorities, Pakistan has about 15-20% minorities, which are Christians mainly. Would be the courts have accorded protection to minorities as the constitution therefore not only caters to them as equal citizens of Pakistan, having equal rights and safeguards, it also provides equal protection to them. In a recent court case, the Supreme Court held that in order to safeguard the rights of minorities and to provide, and also people who are suffering from disabilities, to provide equality of status and opportunities, the state has to endeavor to bridge the gap and ensure that differently abled persons and non-Muslim minority in our country get to enjoy their fundamental rights under the Constitution with the same fervor and force as enjoyed by Muslim majority and majority of persons with fuller disabilities. The court has also come up with a strong jurisprudence on disability, which of course then has a connection with employment, which has a connection with healthcare. It has been observed by the superior courts, and especially the Supreme Court, that Constitution as a whole does not distinguish between a person with or without disabilities. It recognizes inherent dignity of a human being, equal and inalienable rights of all the people as the foundation of freedom, justice, and peace. So the court went ahead and considered the words called disabled, handicapped, crippled, and mentally retarded, deeply bruised, offend, human dignity of persons with different abilities, their use must be discontinued, and the court struck them down from the statute book, saying that they were unconstitutional and they offended human dignity. In another case involving a visually impaired candidate for the competitive examination, which is ICS in your case, the court struck down a rule which hindered their access. They observed that the federal government should formulate a more inclusive recruitment policy, assessing the possibility of providing a reasonable accommodation to disabled persons, where a person with visual impairment was allowed to work for the Foreign Office, and which he went ahead and is currently, as I'm told, working there. So these are some of the cases that I wanted to highlight where the court has robustly gone ahead and interpreted fundamental rights under our Constitution. Thank you so much.
Thank you so much, Justice Shah, for presenting that very sophisticated understanding of the interconnection between what we artificially classify as civil, political, and socio-economic rights. You so wonderfully made that link between disability or gender with access to fundamental rights such as health and education and employment. And I think both the Supreme Courts are on the same page here as far as gender stereotyping is concerned, with the Indian Supreme Court also coming up with a handbook, particularly for judicial officers, to try and tell them that the language that is used, the processes that are there in the courts may actually be leading to, if not, we don't have direct evidence that they're actually influencing decisions, but definitely leading to an environment in which it will seem that they're dehumanizing and degrading towards particular genders. So thank you so much for that presentation. May I call upon Nirin Ankatel to give us a picture from Colombo?
Thank you very much. Do you hear me?
Yes, yes, you're audible. Please go
May I
ahead.
just ask how many minutes do I have?
You have 15 minutes for the initial presentation. Then we'll take a quick round of questions and you can further elaborate on that.
Sure. Thank you very much. Well, thank you very much for extending this invitation to me. I'm very flattered to be a part of this very distinguished panel of two judges and one relatively junior lawyer. So thank you very much for that. I was somewhat hesitant in accepting this invitation to speak at this event for the reason that I suspected that I may strike a fairly discordant note with the rest of the speakers here, and having heard the distinguished Honorable Justice from Pakistan, my fears I think have proved to be right. Unfortunately, I come from a slightly different place, but may I preface that with a couple of introductory remarks. Sri Lanka. Sri Lanka's constitution has a Bill of Rights, but it does not recognize or enshrine socio-economic rights in the classical sense. We, of course, do have a reference to the right to equal protection of the law, which was initially envisaged as a socio-economic type of right, but has since been expanded and interpreted sometimes more broadly in a broader sense. We, of course, like India, we have a non-justiciable set of what we call directive principles of state policy that do talk about economic, social, and cultural issues, but they are non-justiciable. But of course, in Sri Lanka, trends that originate from India do from time to time waft across the Pork Strait, much like the smog that recently covered Colombo. And the tendency for judges to read into the Constitution socioeconomic rights did take off in Sri Lanka, particularly in the early 2000s, for about a decade. And one Chief Justice in particular, Chief Justice Saraten Silva, took a deep and abiding interest in all manner of issues like sand mining, pollution in the city, the preservation of marshy lands and protecting the conversion of those lands to golf courses. All manner of issues were attacked with alacrity by the court. And in fact, in the years when I joined the bar as a lawyer, there were specific days of the week that were in the Chief Justice's court that were allocated to specific issues. For instance, one day there was a sand mining day, the other day was a garbage day, and so on. Entire sitting days where the Chief Justice would preside and would make a series of bench orders, essentially regulating and controlling those issues to the best of his ability. But then in the early, since 2010 at least, there was a withdrawal from that space that the Supreme Court had earlier occupied, and judges, perhaps scarred by the overreach of their seniors, set about a more traditional course. And from 2010 to about 2023, we have really seen the withdrawal of the court from what are classically called socioeconomic and cultural rights. And the courts have adopted a much more conservative, traditional posture with respect to public law rights. Incidentally, this is also a period in which, some critics may say the court rediscovered its independence. These two are not related, and I'm not making the claim that they are, but that's just incidental, by the way. Now, if you come from if you are a proponent of judicial enforcement of socioeconomic rights, then you're beginning to see the green shoots of recovery post-economic crisis. And the court has been much more sensitive to those issues. Recently, the court, 7-judge bench of the court, in a far-reaching decision, held a former president and a whole series of politicians and senior public officers, including the central bank, responsible and liable in a fundamental rights case for violating the fundamental rights of the entire citizenry of Sri Lanka by causing and or not doing enough to prevent the economic crisis that was widely attributed not in Sri Lanka to severe acute mismanagement of the foreign debt problem. So perhaps, the court is shifting. It's a little early to tell. Well, so all of this happens within a context, of course, in which Sri Lanka, with a couple of notable exceptions, of course, you've all heard about the economic crisis. But in a context in which Sri Lanka has had relative success in terms of social indices, we have favorable levels of literacy, almost 100%, if not certainly 100%. Fairly high quality of free healthcare, education, and so on. And these sort of favorable indices have coexisted with very acute problems of governance, very protracted ethnic conflict, an overbearing executive that has dominated the other two other two arms of government, and a beleaguered judiciary as well, that from time to time has attempted to put on a brave face, but has sometimes been cowed by a dominant executive. So in this context, in 2015, President Rajapaksa, who was otherwise believed to have had a complete and total control over the Sri Lankan executive and Sri Lankan politics, lost this major election in 2015 to a former party mate of his, who was a common candidate of the opposition at the time. And this was believed to be a great period of promise for the country, in which we could fix our constitution and our problems with constitutional governance. And so the reformists, if we were to call them that, set about this ambitious course of constitutional reform. The major issues were believed to be the ethnic conflict, and so that's devolution of power to the periphery, particularly the north and the east, in which the Tamil people predominantly inhabit. Secondly, the problem of the executive, and there was a very strong move and a tendency to either eliminate the executive president in toto, or at least clip the executive's powers very significantly and return some of that power back to parliament. And thirdly, to relook at the electoral system. Now, surprisingly, however, there was another issue that, and that being the justiciability of socioeconomic rights that entered the fray. It was not supposed to, no one saw it coming, but it did. And it became a fairly serious and sustained debate, both within discussions amongst the drafters of the Constitution. There was a committee of experts that was appointed in which I participated, and the discussions in that group became quite serious. The divisions became quite noticeable after a while, and this then started bleeding out into academia in general. The bar was resolutely opposed to the idea of the justiciability of economic and social rights, but there were some very serious academics who took a completely different position and wanted to see this written into the Constitution, these rights written into the Constitution. Now, there was at the same time a public representations committee composed of fairly senior practitioners, lawyers, social rights activists, and so on. And they came out with a very, very strong report that urged the inclusion of these rights. Now, I was sort of one of those who took a different position, and I think may I spend the rest of my time perhaps outlining some of the reasons as to why we oppose the inclusion of socioeconomic rights in the Constitution, and leave it at that. The first point that we made, and perhaps in retrospect, we overstated the point at the time, was that the justiciability of socioeconomic rights haven't worked in other countries. Now, the reason why, and we would then point to South Africa, where notwithstanding some very good judgments, as we know, noticeable rise in the lives of the beleaguered due to judicial enforcement of these rights. We pointed to other countries, Latin American ones in particular, that have included these rights in their constitutions. We would point to all sorts of studies and so on. But I think in retrospect, we realized that perhaps that was overstating the point. We don't really know, as a matter of, we don't really know, what influence these rights have had on those constitutions in those countries. But I suppose I would reframe the point to claim that at least in Sri Lanka, we have this intuition that that making these rights justiciable possibly wouldn't work, and have perhaps not the desired outcome, but an opposite one, and would in that sense be counterproductive. And this is because of a deep intuition that the underprivileged would have more power at the ballot than in the courtroom. And I think that intuition possibly has something to do with the current levels of socio-economic, I wouldn't say achievement, but the current relative levels of socio-economic progress that Sri Lanka has achieved through the regular democratic process of elections and political contestation. And also an acknowledgement of what happens in court, the types of people who have access to courts, the way in which judges often interpret legal provisions to the benefit of those who have access to the courts, have access to the best lawyers, and so on. And so it wouldn't surprise us one bit if the greatest beneficiaries of socioeconomic rights in the constitution would eventually in Sri Lanka, if those rights were included, be large corporates, very wealthy businessmen, politicians, and so on. The second point that we made is that the proponents of socioeconomic rights, often in defense of the claim that socioeconomic justiciable socioeconomic rights would lead to courts assuming powers in respect of matters in which they have no competence and of judicial overreach, often point to, we said, the proponents are often pointing to this concept of the deference to the executive discretion, affording a margin of appreciation to the executive and so on, which we seem to see as an adjunct or a corollary to the introduction of justiciable socioeconomic rights. And we believe that those ideas, those set of ideas, margin of appreciation, if you want it, deference, executive discretion, were corrosive to the administration of justice. And our problem, the problem with Sri Lanka, as we saw it, was one in which the judges were already affording, in regular matters of public law, too much deference to the executive, a margin of appreciation that was well in excess of what they ought to be affording, and affording a measure of deference and respect to executive discretion in excess of of that which we thought they ought to be affording. And the last thing we wanted to see was the introduction of a new set of justiciable rights that inherently require the judges to adopt this more submissive attitude to the executive. And we thought that that would have a corrosive effect on our judiciary. The final point, and again, this may be unique to Sri Lanka, but given the moment that we were in, and given that some of us were proponents of radical devolution of power to the provinces, and actually saw the 2015 to 2019 moment as an opportunity to introduce serious devolution for the first time after the 13th Amendment to the Constitution, which was introduced after India's intervention in Sri Lanka's affairs. We were nervous that the centralizing effect of judicial enforcement of rights in respect of matters that would otherwise have assumed were matters of policy would have a re-centralizing effect and would curtail provincial decision making, when in fact what we were really trying to do was to take powers away from Colombo and to the periphery. We were nervous that the Supreme Court sitting in Colombo would perhaps centralize some of these powers by prescribing one-size-fits-all policies to the provinces in a way that we did not want to see. And so, we made these arguments. The debate was civil and respectful most of the time. But eventually, of course, that constitutional opportunity came and it went, and we didn't get any constitutional reform at all. So the conversations were largely academic. But if and when Sri Lanka opens up, if there is another moment for constitutional reform, it's quite likely that these same debates will come to the fore yet again. And, again, we are very keen observers of what's happening in the region. What you do, what your courts do, have a profound impact on how our courts behave and even how we think, really. And so, thank you for this opportunity again. It's been a pleasure. I Hope I haven't struck too much of a discordant note, but certainly look forward to the discussion. Thank you.
Thank you so much, Niren. It was less of a discordant note, and I think something we all needed to hear, both in terms of the significance of comparative constitutional law, as well as what many scholars of comparative constitutional law say are the pitfalls of comparative constitutional law. So if certain jurisdictions are withdrawing on socio-economic rights, then you will find that that ripple effect is not confined to one country, but you also find that similar jurisdictions will also see that withdrawal. And there has been writing on the Indian situation as well, that perhaps the Indian Supreme Court has also not really taken forward its approach on socio-economic rights and has come under the influence of a global move away from socio-economic rights. And even this whole business of transformative constitution that we talk about has largely only occurred in the context of civil political rights and less in the context of socio-economic rights. So thank you so much for raising those questions, both in terms of how we think about socio-economic rights, as well as the significance of comparative constitutional law. And may I now request Justice Bhatt to make his presentation and also respond to these very two different points of view that we have before us.
Yeah, thank you. Thank you, Professor Vasanti. It's been a very absorbing and I would also add enlightening session where seemingly diverse viewpoints have been presented to us. The first from Pakistan by Justice Shah, and the second from Sri Lanka by Niran Anketel. Now, and then taking up on the last comment that the swing away, I would tend to agree that while we celebrate a lot of our achievements, that of our Supreme Court, there's lots to be done and a lot has been undone. And I will speak firstly about what has been undone. Most of us are aware that in the initial couple of decades, there was this rigid compartmentalization between directive principles, part 4 rights or part 4 content and part 3 content. Well, largely it is correct, but if you look into employment law, for instance, interpreting minimum wages laws or industrial relations, the court was acutely conscious that we were trying to build a new society. What it did not get is when it came to agrarian reforms. And that is why the tussle between Parliament and the Supreme Court is so colorfully portrayed as part of a constitutional law. What the court didn't get, if I may say so, I mean, with due respect, is that expropriation is not all kinds of taking. Taking which is towards and which ensures a minimum holding to all, and at the same time ensures that those in holding large extents and tracts of land need to be parted from it at little or no compensation is not to be equated with land acquisition. Perhaps that debate was avoidable if the court had leaned towards a more holistic interpretation of the Constitution and looked into the directive principles. Perhaps if that early perspective were there, maybe we would have been avoided the specter of the 9th schedule even. But then this is all speaking in hindsight. But then coming back to what seems to have been undone. As I said, my practice area had been labor law, employment law for the first 10 to 15 years. And I was fortunate to have joined the profession at a time when you had the likes of Justice Chinnappa Reddy and Justice Bhagwati, Justice Chandrachud, who were, I wouldn't use the word because then it becomes ideologically divisive, who had a different view of law and who adopted what is known as the benevolent or beneficial construction. Now, what is often missed is this beneficent construction has gone back right from the 50s when, a workman who was targeted in a malified manner or victimized, he was given reinstatement. And this is prior to the period when there were specific provisions which enabled labor courts to judicially review the punishments. So that was the era where the courts were liberal and did not have problems in awarding back wages. I don't get into the economics of it, but the point is, post 2000, let's say mid 90s, that jurisprudence changed, and globalization has crept in. Privatization was another, phenomenon which drove this, and as a consequence, one of the unintended consequences, even unions have been destroyed. So while we talk of social justice, let's not talk only about certain part 2, part 3, part 4 rights. Olga Tellez, no doubt one judgment of the Supreme Court in Olga Tellez in 1986, a constitution bench judgment, spoke about the right to livelihood. Now, the right to livelihood, how do you actualize it? Some of these rights are there. They have been given. But how do you actualize it? The right to education was formulated, or rather declared, way back in 1990 by Justice Kuldeep Singh in Mohini Jain. And it lay there for 19 years. It took us 12 years to amend the constitution and another 6 or 7 years for that law to actualize. And even then, under that law, we really don't have empirical studies as to what it has achieved, how much it has achieved, what is its reach and sweep in urban areas and in rural areas. So these are the limitations of, the courts, which we have to be acutely conscious of. At the same time, we cannot be oblivious of the gains. And I must thank Justice Mansoor for giving us a very panoramic and comprehensive view of what they have been able to achieve in Pakistan, whether it's in terms of gender justice or progressive interpretation of rape laws or employment or guarantees to minorities, or climate justice, which seems to have resonated rather close, where the Supreme Court and the courts in Pakistan have engaged rather actively, and which I hope should give us a cue as to what we can do. But on that note, I would say that recently there's a judgment of the Supreme Court in Godavarman case, where the court did go into international jurisprudence of the judgments of the ICJ, and has talked about the principle of restorative justice and set up a committee to assess damages and ensure that appropriate restitutionary measures and restorative measures are taken. So these are all achievements. But if you want me to get into what is social justice and how we have achieved it, my presentation is there. I'll go ahead with it. The question of progressive realization of these rights is important now more than ever in an era of increasing global armed conflict, rapidly declining climate security, and increasing threats of misinformation and disinformation around the world. Specifically, we must anticipate increased challenges to the actualization of socioeconomic rights, such as educational rights, rights to housing, the right to food, the right to safe and healthy environment, to name only a few of the obvious ones. Over the past 3 decades, there have been major developments in the study of comparative constitutional law. In South Asia, constitutional courts have played an important role in protecting and developing the foundations of democratic politics and institutions. This is particularly so in the area of socioeconomic rights. In most constitutions, socioeconomic rights come in one or two forms. One is aspirational, goals or directive principles that are meant to inform state policy or provide interpretive guidance. We are not novel in that. We have borrowed the idea, but expanded and built on it from Ireland. Or judicially enforceable guarantees, the violation of which, including the failure to realize, can be subject to judicial inquiry and remedy. Explicit recognition in a constitutional text is only one sign of constitutional acceptance of socioeconomic rights. Judicial interpretation is arguably or as more important. The interpretation of text is conditioned by the ideational outlook, policy preferences, institutional location, or strategic choices of the courts as well as lawmakers. The South Asian region is unique in the area of adjudication of socio-economic rights, as the region sees major gaps between constitutional aspiration and state capacity. The primary driver of constitutional development is often the difficult reality of state failure. It is in this context that judicial engagement with socio-economic rights in the region must be studied. When it comes to the progressive realization of these rights, national constitutional commitments and national courts have a very important role to play. Social right provisions in the Constitution are part of an enabling legal framework for addressing past injustices and creating a transformed society. Giving courts too large a role in the difficult details of things like housing and healthcare policy cannot remedy the deep inequalities that permeate most developing societies. For one, the courts do not have the capacity. We have the example of the Groot Broom decision in South Africa, where the court could react. But when the court is to frame policies or create something normatively, I suspect it is going to be a very limited role because the court has only that much in its repertoire or that much which it can muster. An approach premised on the courts possessing all answers to how best realize socioeconomic rights can have negative repercussions for democratic transformation. At the same time, courts have a key role to play in identifying and enforcing accountability for minimum core obligations, which Justice Mansoor correctly, if I may say so, identified, the core values. Drawn from interpretations of the International Covenant on Economic and Social Rights, the minimum core concept imposes an unqualified duty on the state to satisfy a defined minimum essential level of benefit for every person. The minimum core has been criticized by several scholars as overly rigid. It could also undermine the transformative potential of social rights. On the other hand, national courts can transformatively use this concept of the minimum core as a tool for developing substantive content of the social rights. Several international and comparative models provide specific guidance on the contours of such minimum obligations. The Groot Broom decision in South Africa, the court's order provided impetus to reforming the state's overall approach to housing rights. The court could say this is not correct, but the court could not insert itself into the decision-making process, which, according to a 2000 judgment of Justice Rao, the primary decision maker is the executive or whichever is the statutory body. India has not been far behind. Right from 1970s and 1980s, the full impact of the directive principles, which are set out in Part 4 and spell out the obligation for progressive realization of social justice incrementally, have been felt. Many of the provisions of these DPSPs, as we call them, the acronym, correspond to the provisions of the ICESCR. The early 50s and 60s saw the direction of the state in massive agrarian reforms. This met with some success in a few states, whereas in others reforms were slow or at a standstill. These agrarian reform laws led to tremendous social churning wherever they succeeded. Yesterday's wealthy were divested of their holdings beyond the minimum applicable. As I said, Indian courts were seen as obstructionist at that stage. For some reason, the judgments of that time adopted a binary of expropriation or acquisition based divesting as opposed to land reforms badly needed to equalize society. A second generation reforms in 1980s and 1990s in various states took forward these ideas. The courts in India started insisting that statutes have to be read or interpreted in the background of and context of Part 4 provisions. Various aspirational rights, such as the rights to livelihood, health, clean environment, education, and so on, acquired prominence. Due to the scheme of the Constitution, a unique adjudicative approach adopted by the court has been that violation of a socio-economic right has been linked to the violation of a civil political right. For instance, in Olga Teles, the Supreme Court linked the right to life under Article 21 with the right to livelihood under Article 39. Now, to be specific, in that case, pavement dwellers and hawkers were being turned away without a hearing. So the court could say that the court was being reactive. It reacted to the situation. So that begs the question which I am posing before you and hoping you will all get into. How does the court create rights, enforceable rights? How does a court create rights to a particular policy so that they get actualized and actually translated in favor of the people? That question will always confront us when we look at these rights. In the sphere of socio-economic rights, now we have the tools, and I'm going to speak now about the tools that Justice Shah mentioned about suo motu powers. Similarly, in the early 80s, late 70s and early 80s, which altered our rule of standing. So we have this very widely studied phenomenon of public interest litigation, which enables people to go directly to the courts and seek justice and enforce certain provisions or point to injustice wherever it occurs. Now, the court has been using this and also coming out with certain innovative orders which are declaratory. Certain examples are always stand out. One is the Vishaka judgment, which tried to actualize certain rules. But then again, the court's limitation is there in that, because the court mandated certain rules to be followed at every workplace, limited to state establishments. You needed a law, and it took 17 or 18 years for that law to come, which actually horizontalized its application across to all private establishments, and not just state establishments. The second species are what the court called as continuing mandamuses in Vinit Narayan. On the other hand, there are specific time-bound directions to errant administrative or state authorities, which could be either not acting in accordance with law or not acting at all, requiring it to take specific steps. An example of this is what Professor Vasanthi mentioned, the PUCL judgment on the right to food, which gave elaborate directions to ensure that excess food stocks were made available even in rural areas. We also have the interpretive doctrines such as beneficial construction or welfare laws, as I mentioned in the case of labor and minimum welfare legislation. Then we have innovative interpretations where the court appointed commissioners to go and see particular instances of violations in bonded labor and other such acute violations of statute law. Adjudication by the courts in this manner can have some positive implications. It can enable creation of a space for an issue that would otherwise not have invited sufficient attention. It can catalyze changes in law and policy in the area of socioeconomic rights. Many of the changes in law and policy relating to education in general and primary education in particular are owed to the decision in Unni Krishna. And it can devise benchmarks and indicators in several key areas concerning economic, social, and cultural rights. For instance, the decision in Paschim Banga Khet Mazdoor Samiti delineates the right to emergency medical care for accident victims as forming a core minimum of the right to health. In the context of these rights and their adjudication, there is need for remedies that promote ongoing interactions among the state, civil society, and affected communities. What our Chief Justice currently in many instances has referred to as a dialogic process, which is very commonly used in South Africa. Our framework, of course, is different because the South African, there are express provisions which enable the courts to not merely declare, but also involve themselves in the norm-making process, those provisions are lacking. And yet, having said that, we must also acknowledge that the South Africans have borrowed many of our ideas when they were making the constitution. And it's been a very thought-provoking session for me, learning perspectives from Pakistan and Sri Lanka. Thank you very much.
Thank you, Justice Bhatt, and thank you to all the presenters for raising so many questions, which I hope the audience will take further. So I throw the session open for questions.
Hi, am I audible? Yeah. So my question is for Justice Bhatt and anyone who can pitch in on this, in relation to the aspect of continuing mandamus, especially in the context of demolition drives that are on rise in the country. So on one hand, while we do have the enforcement of positive obligations through, let's say, NHRC or SHRC, who are just sending notices to district collectors saying, okay, you have not enforced these particular laws that are being implemented. But on the other hand, when we talk about continuing mandamus, as Justice Muralidhar also has pointed out time and again, that the nature of interim relief is very important in these cases. And unless and until the court steps in at the right time, the entire, I would say, discourse around socio-economic rights and preventing demolition falls flat. So is the Supreme Court, and very recently I came across one of the proceedings where I think Justice Muralidhar was appearing for some slum dwellers and some eviction drive. Is the Supreme Court willing to go on or take forward the idea of continuing mandamus and step in at the right time in the nature of interim relief?
Yes, thank you. Hi, this is Advocate Rahul Bajaj. I have two questions. One for Justice Mansoor Ali Khan, who mentioned about the Pakistani jurisprudence on disability rights. So he focused on the negative aspect in terms of the Pakistani Supreme Court striking down the use of terms like mentally retarded, etc., as well as the positive dimension of requiring reasonable accommodation measures to be provided in the civil service and so on. So I was just wondering if he could reflect a little more on this sort of dichotomy, because he did say that the court recognizes that persons with disabilities cannot have to be treated at par with others, but then at the same time there is a need to provide them additional support, which others who are able-bodied are not to be do not need. So that's one part, and the second one is a more practical question for anyone who can chip in on this, which is for a lot of people in the audience. They would be keen to know how to practically pursue socioeconomic cases, right? So a lot of people, other than studying academically, in addition to that, may also practically want to become lawyers who are actually practicing such kinds of cases. So what are some ways to actually spot litigation opportunities and be in positions where you can positively influence the jurisprudence in this area? Thank you.
My question comes in light of the climate change jurisdiction highlighted by Justice Shah, and it is directed to Justice Shah and Justice Bhatt. Sir, the Indian Supreme Court in many cases have called for looking environmental issues not from the lens of how it violates human rights or anthropocentric lens, but rather from an ecocentric lens. And if I may quote from the Indian Supreme Court's judgment in Tarun Bharat Singh versus Union of India, where it was remarked that government above big business, individual liberty above government, and environment above all. And TV Godwaram case, which I think Justice Bhatt mentioned, it was remarked that environmental justice could only be achieved if we drift away from the principle of anthropocentrism to ecocentrism. An example in such an approach would be the 2008 amendment in Ecuadorian constitution, which empowers citizens to litigate on behalf of an ecosystem, even in the absence of any infringement of fundamental rights of humans. So what are your thoughts on such a shift in climate justice and rights jurisprudence? Justice Shah and Justice Bhatt. Thank you.
Hi, sir. My question is for Mr. Niran. So I found it very interesting that you mentioned that the reason that you and the bar did not think that the justiciability of socioeconomic rights won't work in South Sri Lanka specifically is because of the composition of the people who have access to the bench and the fact that the beneficiaries of any interpretation would be a specific type of people, like a specific class of people. Now, I think that goes very contradictory to our understanding of the Supreme Court, especially being the constitutional court and therefore being a counter-majoritarian institution, which has the primary authority to defend rights, primarily because we understand executive and legislature to be entirely partisan bodies. So, and I think the composition of the bench or the bar is not really often stressed that much. So here I wanted to ask if you could elaborate on this in terms of, is there something unique in the nature of the jurisprudence for socioeconomic rights in particular, or if there's, or if you think that the political representation in Sri Lanka has been such that it has actually been able to serve those purposes. And secondly, since you mentioned that the relatively limited amount of socioeconomic progress that has happened has been through political processes. Now, in a situation, for example, the one that we are facing in India with like a single party majority, where those political processes simply don't seem to be working, what would you suggest is an alternative if the justiciability does not work?
Can I invite Justice Shah if you would want to respond to these questions?
Sure. Thank you so much. I really enjoyed Justice Bhart's uh, talk, and it was very illuminating. I really enjoyed Narayan's view on the subject, and it's very interesting. And on a lighter note, maybe he visits Pakistan sometimes and has a look at the Pakistani Supreme Court, who seems to be quite on a totally on a totally opposite to what's happening in Sri Lanka. But then that's a discussion we can have. Just responding to the first question regarding continuing mandamus. Yes, it has done wonders for us in Pakistan in the environmental front as well as on the climate change front. One of the unique things that we've done, which has really carried our environmental movement forward, or judicial environmental movement, or climate change movement forward, is the constitution of a commission. So not only is it a continuing mandamus, the court also goes ahead and constitutes a commission. The court realizes that this is an inquisitorial jurisdiction, and the court cannot spend time in coming up with solutions and looking at all possibilities, all possible fronts that could be addressed. So the court in the climate change case came up with a commission called the Climate Change Commission, which constituted of the international NGOs like the WWF, like IUCN, local experts, lawyers, civil society, government representatives. And I, being the author of that case, I felt that when the matter came up on the first time on climate change, we realized that once the government was put on notice, we felt in the court that the government had no understanding of what climate change was. They were just talking about global warming 101, like any standard textbook thing, but they had no idea. Yet the government had a very sophisticated policy in place, but the executioners, which is the executive itself, had no idea what they had written actually. So we thought that the capacity was also required to be built in this regard of the executive, and the commission came out to be an ideal solution for this. And the commission then carried the agenda and reported regularly to the court. So continuing mandamus mixed with the concept of a commission did wonders for us in this context. And we were able to, with this, a joint strategy of continuing mandamus with the constitution of a commission, be able to come up with about 60 to 70% of implementation of that policy. And at the same time, the executive, building the capacity of the executive in dealing with these issues, it went wonderfully well. So if that was the question, for us, the continuing mandamus has been of great help. And this is, currently I'm dealing with a climate change case where it's a public interest matter where citizens have come forward and said there is a Climate Change Act which talks about setting up a climate change authority and talks about setting up a climate change fund, which is essential because the country has recently suffered, really devastating floods. So the court is going ahead as on a continuing mandamus manner to ensure that the authority gets into place and there is a climate change fund also put in place, and the federal government is going to respond to that slowly. So it is, in the context of public interest litigation, continuing mandamus has been rather beneficial for Pakistan, very effective also. Coming to the question of disability, if I could answer all the questions that were addressed to me, Professor Vasant.
Please do. Yes, please do.
Okay. So a question of disability. Now, this is a very, very proud of this jurisprudence, actually. Some of the judgments, I mean, without boasting, I'm saying that I say this because I feel very passionate about this issue. So when we struck down those words, that was not a negative thing. We were saying that the proper word to be used is persons with different abilities. And words like handicapped and others are not correct and appropriate words anymore. And this sensitivity needs to be brought in. And that's why we struck down those words from the statute book. So that was one positive step, as I would imagine. And we also brought in the concept under the International Convention of reasonable accommodation. And we informed the audience as well as the government in that case, that reasonable accommodation is possible. There is assistive technology available where all these people could work. Initially, the response of the government was that how could a visually impaired person ever work in the Foreign Office? And now I tell you that he's one of the senior most officers in our Foreign Service because of the assistive technology available. Let me also tell you that when I was the Chief Justice of the Lahore High Court, we inducted our first civil judge who was visually impaired. And initially, my judges at that time said, how will he handle the court? And how do you know, you've seen a civil court, how busy it is, and how will he handle it? And I tell you, he's one of our most efficient and one of the, one of the best judges we have in the Lahore District Judiciary. He uses assistive technology. All that was required was to supply him or equip him with the relevant assistive technology, and there he went. So I think the disability cases, which are more than one, have brought in the concept of reasonable accommodation and made the governments, the federal as well as the provincial government, sensitive to the fact that there could be a reasonable accommodation provided, and the persons with different abilities can be mainstreamed and brought in, because the Constitution does not make any difference between a person with or without disabilities. All the fundamental rights as are available to a regular or normal person are available to persons with different abilities. And this has gone ahead in, I don't have the time, but there are other disability judgments where we've interpreted the law in favor of persons with different abilities. And so that is that. Coming on to another side question, that how would lawyers look at this? I would imagine that a lot of young lawyers are bringing a lot of public interest litigation petitions in the Supreme Court here, and they used to do that at the High Court also. So you could raise a number of social causes which could have socio-economic rights, or as we would say, which violates or infringes on fundamental rights. There's been a recent inflow of a number of cases that have come to us. And so that could be a start. You see, I myself, when I started practice, I took up a first case of air pollution to the court. And I still remember this was way back, 2 decades ago or so, when I took the matter to the Lahore High Court and I said, sir, air pollution is a serious concern. And that's the time when there was no environmental movement in the country. The judge said, okay, we'll take up this case later. I have to attend to some criminal and rape cases first, and this fancy litigation can wait. And I was quite disheartened. I thought air pollution was such a serious issue. However, the court took it up at the end, and then slowly we progressed, and sort of that kind of an insight came into the understanding of the judiciary at that time. But so what happens, and I think it will be great for, and I used to teach before I became a judge. I taught at LUMS, which is perhaps, if not equivalent, something as close as Nalsar in Pakistan. And the whole class signed up for a petition on public interest, and I was teaching them business law at that time. And we went to court with my students to challenge a particular, there was no landfill in Lahore, and we thought there should be a landfill. You can't just throw garbage out on the side. So the first petition we filed on behalf of the students of LUMS was a petition on having a landfill. So Nalsar could do the same if they so wish to do. And just answering the last question on climate change, we have increasingly moved away from anthropogenic justice system. We are now saying that we need to have a biocentric approach. The concept now is not dignity of human beings, but dignity of nature. And once you talk about dignity of nature, you automatically talk about dignity of human beings. So the court has gone ahead in DG Cement case, if you can look it up, where we've talked about stopping a cement plant from being set up, where we talk about biocentric rights. We're talking about future rights of the future generations, which are going to be affected by not taking appropriate measures now and saving our resources and not preventing environmental degradation. We've also talked about a legal personhood for nature. And that is important, that the trees could have a legal right, and so could other living nature could have rights to come to court. So that appears to me quite a progressive judgment. It also talks about climate democracy, that a democracy that we envisage now is to be friendly and has to understand climate concerns. So so the court has already moved beyond anthropogenic kind of human-centric approach to a more biocentric approach in understanding environmental issues. And I think, personally speaking, I think unless we move towards nature and go beyond human rights, we will not be able to fully understand how will we address the issue of climate change, water justice, climate justice, which are serious concerns, very serious existential threats to my country, certainly, and I'm quite sure to South Asia. And I think this is the future litigation, unfortunately. But I think if young students would like to jump into climate area, this is a growing area which requires a lot more assistance and inputs. Thank you.
Yes, Niren, would you like to respond to some of the questions?
Yeah, thank you. I think there was just one question, and a request that I clarify, my point about access to the courts. I think the question that we tried to raise was, who are the people most likely to access the courts if we make economic and social and cultural rights justiciable? And it's a sad reality of life that competent lawyers most likely to obtain results in court have to be properly retained. Now, that costs money. There's also the question of whether those most in need of interventions, judicial or otherwise, would have access to the courts. Second, those who would have access and so be in the best position of influencing the jurisprudence of the court on socioeconomic rights, would have an incentive of coloring that jurisprudence in a way that perhaps doesn't work for the most marginalized sections of society. Now, someone may say, of course, you've got public interest litigation, but here too, NGOs, activists, and others with the greatest ability to mobilize and bring litigation before the court privileges a certain kind of activist, a certain kind of public interest activist, one who is more influential, urbane, closer to the law and to the center over those at the peripheries. So that's the series of concerns that I wish to raise. I mean, of course, one may also argue, well, these problems obtain even with the enforcement of civil and political rights. But the difference here, I think, is that the introduction of socioeconomic rights is done precisely on the basis that those rights are required by those at the periphery, those out of sight, those who do not have access to the center. And it seems to me that perhaps those are not the people most likely to obtain the benefit of the introduction of these rights in the Constitution. Second question, of course, which is a very provocative one, what's your alternative if justiciability does not work? And I really don't know. But I would caution, however, in assuming that in an unfair political climate, that within an unfair political climate, if such exists in your country, I don't know whether it does. I'm not competent to comment on it. But assuming you have a corrupt and unfair political system that is not responsive to the needs of the people, it's not clear to me that you could then assume that the judiciary would act fundamentally differently to the executive in that particular situation. Seems to me that a competent judiciary, a judiciary that respects rights, also requires a general political climate in which rights are respected, in which the rule of law is upheld, and so on. But that is certainly a provocative question, and one that I will think about at length. Unfortunately, there are no glib answers. Thank you.
Thank you, Nidhi. This is back.
Yeah, a couple of 2-3 questions were directed towards me. The first one, I think, is about the demolitions and interim orders. I can't speak for any particular court, but I think it's a question of sensitization and how sensitive are the judges or the benches. When issues of demolition of interim relief of that kind come up, I would ordinarily assume that a sufficiently sensitized judge would take it up urgently and ensure that the entire issue doesn't become infructuous. Because these rights are valuable. So it's not only the demolition of someone who is affluent, moneyed, but also structures which the authorities allege are unauthorized or slums. Now, the Olga Tellis judgment says that everyone has the same rights, the same right to hearing, and a minimum right of opportunity. But in actual practice, how much of that is actually implemented? And that's the question which the courts have to answer or ask themselves every day. And that's the only way I think I can answer that. Now, coming to the difference between the anthropocentric, ecocentric, and what the judge, Justice Shah, mentioned as the biocentric, I think that kind of consciousness is now there in the Indian Supreme Court. We have just to watch in the future how many of these concepts actually get assimilated in concrete judgments and what is the action that the court takes. From 1997, we have had this Godavarman case, which is a continuing one. The docket of that case has become almost unmanageable, but there are distinct segments to that: forest, climate, and so on and so forth. And in terms of wildlife and forests, certain kinds of things, there is central empowered committee which the court set up way back in 97, and it has reconstituted. The court's jurisprudence has led to legislative changes in framework, regulatory frameworks, and so on. So as we go forward, I would assume that that space should get filled up and there should be more awareness of the people. But I'm afraid at the same time that the competing values of development will always come and challenge these norms. And that's where the courts have to take this up urgently. What value do we give to development, to roads, to destruction of forests, or cutting up of mountains, when we talk of maintaining the integrity of those forests, and what is the long-term implication of that? I think that awareness of that whatever is being done will impact not only us in the immediate present, but also the future, as we call as the interdisciplinary and future generation rights, has to be made, has to be reiterated amongst every generation of lawyers, and more importantly, every generation of judges. Then I think we will reach some place. And the third question is, I think, Rahul's about reasonable accommodation. I hope Justice Mansoor's answered that question. About reasonable accommodation, Rahul, you're aware there are any number of judgments. But what struck me was this reasonable accommodation has been seen in India from the lens of the statute as it exists, which lists out certain disabilities, I think 7 in number. Now, there are many other conditions which are not listed as disabilities, or, conditions which should receive reasonable accommodation. And yet, and I think that space has to be filled by the courts very creatively. And some of these conditions, in fact, the one size fit all, I had remarked in one of the instances in the Delhi High Court, when it comes to mental health, that the eligibility for concessions is 40%. So there was a case where someone had 60 or 70%. That 70% was, at one level, it was accommodation was possible because the certificate enabled the candidate to that benefit. But at the other level, that level of disability disqualified him or her. So I think there needs to be constant engagement with the normative process as to the viability of these norms and why exclusions happen, and why even those exclusions can be addressed from the larger, perspective of constitutional law in Article 21, Article 15 and 16. That's one part of the question. The other part of the question is how do you have what kind of access do lawyers who are interested in this kind of social welfare litigation, how do they gain entry in the courts? The first thing that I would say, which I never had the opportunity, was engage in criminal matters. There is no dearth of opportunity. There's no dearth of poor people who need representation. The second is the underdog. I had the privilege of doing it, of course, at the Supreme Court level. I was getting almost all my cases from people who are dismissed employees or who were not paid wages. And that gave me a huge opportunity to engage with this kind of litigant, and also a lot of satisfaction as a human being. So I can't say that these are the only methods of doing it. I'm sure now there are so many sectors and segments where young lawyers can get into. The NGO movement in very many segments, such as child rights, juvenile justice, also is very demanding, and I think there can be opportunities there. I hope that answers your question.
So let me thank all the presenters as well as the audience for such an engaging presentation and questions. I think we've covered many issues, and I think the division that we often make between socioeconomic, environmental rights, criminal law, labor and employment, I think this session has really made sure that these divisions no longer may hold as much significance, and we have found a way in different jurisdictions in different ways to be able to address questions of social justice across this division of what these rights are. I thank all the panelists and the audience for this session. Thank you.
Thank you very much for having us. Thank you.
Thank you. Thank you.
Thank you very much. Bye-bye.